Good morning. I expect a response. Thank you very much. I'm glad I have your attention. You're very welcome to this special event. It's Aluko Oyebode's International Trade Practice Day. And today we are going to be dissecting issues relating to the Africa Continental Free Trade Agreements. We have experts from different fields. We have lawyers, we have people, who are really trading and using the AfCFTA. And we're just going to discuss some of the benefits or not so, and threats and opportunities of trading under the AfCFTA. I would invite Mr. Mark Modi, SAN, to welcome us formally, and then we'll just jump right into why we're here. Thank you very much.
Good morning, welcome everybody. On behalf of Aluko Oyebode, I use this opportunity to welcome those online and those physically in the room to this our inaugural international trade seminar webinar that we're running. It's the very first time that we're running one, and I just want to say welcome to all of you. I also want to say especially welcome to our distinguished speakers who are some are online offsite and some who are physically present here, who have abandoned all the stuff that they're doing to come and give of their wealth of expertise. I'm especially welcoming my friend and colleague from South Africa, Mr. Melu, who's a partner at Weber Wenzel in international trade, Mrs. Olushe Alayonde, Sheon from Stanbic IBTC, Luisa Setina from A&K from Kenya, as well as Daniel Ngumi. You're welcome, all of you. God bless you. I just want to use this opportunity to welcome you on behalf of the board, the chairman, our founder at Aluko Oyebode, and all the other firms that are collaborating with us on this project, the A&K, Anjawala and Kana, as well as Weber Wenzel. Thank you and welcome. We're going to move into an overview of remarks, and I'll leave Lyre to introduce our distinguished speaker, who's going to give an overview on international trade. But I think sometimes it's useful to strip things down to their bare essentials in order to catch the essence of why stuff gets done. What does international trade do? Why is it an imperative? Guess what? It allows scarce resources to be redistributed with ease. It allows prosperity to flow. You have the EU as an example. It will allow, it allows those who have not to have. It allows those who have been blessed with gifts, talents, and natural resources to become a blessing to several other kinds of people around. And there's an interdependence that exists in our world today that international trade just, encompasses. So with that small, background that I provided, I want to invite back Irisimi can we give her a round of applause, please? Let's invite back our MC, Irisimi, to come and invite, to usher in our first speaker. Again, welcome, and I hope that you have a wonderful time today.
Thank you very much, Mr. Modi. So we're going to take our very first speaker, who's going to introduce us into the subject that we are discussing today. His name is Professor Jonathan Adeyemi Aremu. He's going to be joining us virtually. He's the Professor of International Economic Relations and a former acting Vice Chancellor of the Covenant University, Ota, Ogun State. He's also a consultant at the Economic Community of West African States, ECOWAS, the Common Investment Market, ECIM, and he's going to be joining us virtually. Please, can we have Professor Aremu? Thank you.
Thank you very much. I'm still muted. Can they allow my picture to be seen?
We can hear you, Prof.
Okay. Well, thank you. I'm expected to give a brief overview of what the economic integration of Africa is, particularly the first phase of it, which is the African Continental Free Trade Area. No doubt all of us know that we have been marginalized from cradle of civilization as slaves, as former colonies, and the neocolonialism has aggravated the position of African nations to the extent that our product does not command respect in the international market, and therefore we couldn't have access to the desired revenue that is needed for economic development of the continent. Therefore, since African Union was born in 1993, efforts were made to have series of meetings to be able to make sure that this does not continue and the marginalization to some extent is actually put on check. But the greatest of the meeting was the Legal Plan of Action of 1980. At that particular meeting, the entire head of state of Africa decided the kind of economic integration roadmap that we allowed for the emancipation of the continent so that we shall not continue to remain as producers of wood and fuel for the entire global economy, but part of the continent that actually can be seen as making substantial contribution into the global space in terms of products that are manufactured. Thereafter, in 1991, the African Economic Community Treaty was actually launched, and it is titled Abuja Treaty. Why? Because again, just like the predecessor that was Lagos Plan of Action, it was actually put in place in Abuja, which is equally Nigeria. At that particular meeting, the various stages of economic integration through which Africa will go through was put in place. And essentially, that meeting recognized 4 phases of economic integration. Now, first, we are going to move from free trade area. Secondly, we move to custom union. After custom union, we go to common market. And after the common market, we now go to economic union. And that exactly is what we are doing today. We are just at the first phase, which is African Continental Free Trade Area. And the free trade area is a situation in which member states will remove every barrier as much as possible with respect to import duty and non-trade barriers that have been disturbing us from trading with ourselves. Let me quote some little statistics. And what are these statistics? You look at the European Union, over 60% of their international trade among themselves. You go to NAFTA, North American Free Trade Area, as much as over 40% among themselves. You go to Asian economy, over 36% among themselves. Come back to Africa, less than 15% of tradables among ourselves. So we have been preferring to trade with Europe, with America, with Asia, and not ready to trade with ourselves. So African Continental Free Trade Area, which is the first phase of economic integration in African Economic Community, recognize that we need to remove impediment to trade, particularly import duty, as well as other non-trade barriers. And on the 21st of March, 2018, which is a historical date, the African Continental Free Trade Area was launched in Kigali at Rwanda. And quite a lot of countries enter into it, sign into it. Nigeria did not sign into it initially, but Nigeria on the 7th of July 2019 signed into it, and we ratified the treaty on the 5th of December 2020. So Nigeria is equally a state party, and Nigeria has gone ahead to develop a national strategy assisted by UNECA, United Nations Economic Commission for Africa. And therefore, we have a national strategy of how we want African Continental Free Trade Area to be implemented in the country. So our assembly this morning is to look at that particular topic, African Continental Free Trade Area, with respect to opportunities go to offer us, as well as identify the threats so that we can ensure that we minimize the threat and we magnify the opportunities. Thank you for the opportunity to give this overview.
Thank you very much, Prof, for that insightful overview. Maybe some of the things that we learned today, about trading under the AfCFTA would help us attain such economic progress, and development, such that we would not be having issues, with NEPA taking light, So we'll just go right into the panel discussion. So we're going to be having 2 panel discussions today. On one hand, we're going to be discussing some of the practical issues. The people who are really using or trading the AfCFTA, they're going to come and testify, to the AfCFTA and how far we've come since it was signed and how far we can go. And on the other hand as well, we have people who are going to discuss some of the theoretical issues. But I assure you that there's going to be a lot to learn here today. And so very quickly, I'll just introduce some of the panelists. Many of our panelists are joining online. Thank God for the power of technology. We have people from all over the world here. We have someone from South Africa. Thank you very much, sir, for joining us. We have people joining us from Kenya, and from all over Africa. And so I'll just introduce my panelists very quickly. Their bios are going to be displayed on the screen, so I'm not going to read out the details of their bios. So the first person is Mr. Francis Anatogu. He's a Senior Special Assistant to the President of the Federal Republic of Nigeria on Public Sector Matters and the Secretary of Nigeria's National Action Committee on the Africa Continental Free Trade Agreement. Let's put our hands together for Mr. Francis Anatogu. He's going to be joining us virtually. Second, we have Mrs. Olusheye Alayonde. She's the Chief Group Legal Counsel and Company Secretary of Boa Group. Please let's put our hands together for her. Thank you very much for coming, Ma. And third, we have Mr. Seun Ogundolapo. He's a banker with Stanbic IBTC Bank with over 21 years cross-sector experience in trade operations, international trade finance, transactional business, and transaction structuring, amongst others. Please let's put our hands together for Mr. Ogundolapo. And of course, we met Professor Jonathan Adeyemi Aremu earlier, a professor of international economic relations and a former acting vice chancellor of the Covenant University, Ota. And fifth, we have Ms. Luisa Setina. She's a partner at Anjawala and Kana, ALM Kenya. Please let's put our hands together. She's going to be joining us virtually as well. We have Mr. Tola Onoyemi. He's the Chief Executive Officer of Norbase, as a company with a single digital infrastructure for businesses to start, scale, and operate in any African country. He formerly served as an assistant chief negotiator for Nigeria and head of the trade remedies at the Nigerian office for the trade negotiations. Please let's put our hands together for him. And next we have Mr. Daniel Ungumi, also a partner at Anjawala and Kana, ALN, Kenya. And so before you think that there's not going to be anybody in the room, and before you think that all our speakers are virtual, I'm just going to introduce some of our speakers who are right here in the room. Please let's put our hands together for Mr. Meluleki Nzimande. He's a partner with Weber Wenzel, South Africa. If you could please come up to the podium, sir. And then, of course, our very own Mr. Tonye Kukubo, Senior Advocate of Nigeria, a partner in the law firm of Aluko Oyebode. And Mr. Mark Mordi, SAN, a partner in the law firm of Aluko Oyebode. Thank you very much, Mr. Kukubo. Over to you.
Thank you, Larismi. I think, Larismi, there's one person missing that I think should be on the rostrum with us. I just had a brief discussion with her before we came on, and that is Ms. Olusheye Alayonde of BUA, of BUA. So you're welcome. Our discussion today is around the AfCFTA, threats and opportunities. And I think Prof gave a fantastic insight as to what the genesis, the origins of the AfCFTA, and why it's so essential that as lawyers offering diverse legal services, we need to essentially understand what it's all about. The purpose of panel B is essentially to look at legal and regulatory issues around the AfCFTA. And I'll be calling on our colleagues from A&K, Louisa and Daniel Ngumi, and occasionally reference will be made to my sister here, Mrs. Olusha. Now, 1.3 billion potential consumers, well over $1 trillion in terms of expected revenue. 55 countries are all those who are meant to benefit from the AfCFTA once it actually starts in full swing. We would hear today if that has actually taken off the way we expect, or if there are issues that we all need to be aware of that would impede on the taking off of the AfCFTA. But one of the areas that we would look at, as earlier mentioned, is disputes. When you have that many potential consumers, there definitely would be issues that occasionally will call for some form of resolution. Is the AfTA prepared? We're all fully aware, at least those who have taken time to read the protocols and the rules, that the AfCFTA essentially mirrors the World Trade Organization in terms of its dispute settlement mechanisms. If you know the workings of the WTO, it has something called the DSU, Dispute Settlement Understanding. That essentially is an acronym for a process that allows for what you call state parties to resolve issues that arise from disputes resulting in world trade. That essentially is what AfTA seemed to essentially have copied or modeled its dispute settlement mechanism against. Louisa, I don't know if you're on, if you can hear me.
Yes, I can hear you. I'm sorry. I've been trying to turn my camera on, but I think I'm not allowed by the host, but I can hear you well.
Okay, thank you, Louisa. We have your photograph and everybody can see you. So I'm sure they have a picture of what you look like. But thank you so much.
That's great because that's an old picture, so it makes me look younger.
Thank you, Louisa. So, Louisa, let's start with you. I mean, we've had brief discussions around this, and it's interesting that this conversation is going on. For those of you who are not aware, we had initial discussions at an event sometime in January with A&K, also around the AfCFTA. And Louisa, considering the developing character, if you will, of countries within the African continent, do you think, considering also the arguable success of the dispute settlement understanding processes in the WTO, after which the DSM of the AfTA has been modeled, that there is any chance of a similar success of dispute settlement under the dispute settlement mechanism of AfTA? Louisa.
Thank you. Yeah, that is a very good question. And I would like to point out that actually the WTO does have a very successful record, but as some of you may know, has had several challenges over the last few years and has been fighting to survive because of the veto by the US of the constitution of its appellate body. But it does have a long record of successfully adjudicating disputes. And as you mentioned, the AfCFTA basically transplants large sections of the understanding under the WTO in its dispute settlement mechanism. Personally, I am quite optimistic. I think that for the AfCFTA to be successfully operationalized and to give states and other parties trust in the system, there needs to be a rules-bound mechanism to resolve disputes. Some of the commentators have observed that one issue with transplanting a foreign system onto the continent is that it may not cater to some of the preferences of states on the continent to avoid more formal dispute resolution processes in instances of disputes relating to trade issues. Even if you look at the process before the WTO, African states have been quite reluctant to go before its dispute settlement body. And on the continent, the track record of states going before regional economic blocs mechanisms is relatively poor. African states have traditionally preferred diplomacy in these types of scenarios. However, the dispute settlement mechanism under the AfCFTA protocol does provide for consultation before any dispute is referred to the panel for adjudication. So personally, I think that the fact that there is the possibility of consultation caters for that preference towards diplomacy, but the availability of a more formal dispute settlement mechanism through the panel and then the appellate body is quite helpful, and I'm hoping that it will be used. I do think that there is a need to encourage states or to incentivize them to go before these bodies, to have enough properly trained lawyers who can assist with regards to these disputes, and for mechanisms such as compensation and I don't want to use the word retaliation, but other mechanism to incentivize enforcement of rulings. Hopefully it will encourage state parties to engage, and it will also, I think, enhance a vibrant legal community that is well versed in trade issues around the continent.
Thank you, Louisa. Thank you for that wonderful insight. And I'll continue with our virtual guests. There's a young man whose photograph you just saw, picture you just saw, Tola on IME. Tola, are you on?
Yes, I am. I'm on.
Yeah, Tola, hi, good to see you again. Now, just before you give your own insight, I don't know if you heard the question Louisa just spoke extensively on. Before you give your insights on those on that question, I think what we need to know about Tola is, his CV is a page or two long. So let me just quickly highlight what I think is important for us here. He formerly served as an assistant chief negotiator for Nigeria and head of trade remedies of the Nigerian Office for Trade Negotiation, NOTN, where he led portions of the technical negotiations for the AfCFTA. So Tola has some in-depth knowledge of the operations of the AfCFTA. So Tola, what's your own take on the possible successes in terms of how African state parties can resolve their disputes when mirrored against the obvious success of a similar scenario under the WTO? Tola?
Thanks a lot. That's a very helpful question. And I think before we even get into that, I think one interesting update to give is where exactly that dispute settlement actually right now is. So there's a committee on it. Each of the member states, the 54 member states, have nominated 2 panel members that have been to be part of that dispute settlement panel. I know also that they have now finished the selection of the 7 appellate body members. I think this is supposed to be inaugurated sometime next week. I am right. So the DSB is coming together. By the way, the funny joke is the AfCFTA calls their own DSB, the WTO calls its own DSU, right? DSB is, dispute settlement body, not much of a difference from a structural point of view. And when we're trying to design the AfCFTA, the idea was that you wanted to make it of reliance on the dispute settlement system in the WTO. And the reason was simple. The WTO had enjoyed a lot of success of that dispute settlement mechanism. In fact, when you read a lot of articles, you would see them say things like the DSU is the crown jewel of the global trading system. And the reason was simple. In other international agreements you ever read before now, you would notice that there was a lot of weighted system to how powerful you were as a country. So for instance, if you went to look at the UN system, there's a Security Council that can veto almost what everybody else can do. When you look at any other body, what made the WTO special, which was one of the reasons why it was borrowed into the DSU, was that every member state almost had the same playing field. Like a company as small as Mauritius could actually block something that had to do with the US. And the reason was simple. The reason was that every member state had similar voting power. But when you went to the dispute settlement, what happens basically was member states basically converted, in a sense, to a kind of panel, right? And so what happens is that each member state nominated panels. Countries that had disputes would go to the panels, and from the panels, decisions would be made whether they thought you were right or you were wrong. And what's interesting was that if you did not comply, member states that had the right to retaliate against you, they would say something like, I would also not honor your obligation, even under that agreement, or even under a different agreement. And so what made WTO so powerful was that dispute settlement structure. Now, but one thing you saw with most African countries,
Depending when Tola comes back on. Melu, any insights? Yes.
Good morning, everybody, and thank you for this opportunity, and in particular, the opportunity to be here with you physically in this beautiful city in West Africa. Yes, I am one of those who are optimistic about the use of a dispute settlement mechanism which permits access to state parties to deal with their disputes. There has been concern expressed from certain quarters. I know Tonya is one of those people who believe that the mechanism should allow non-state parties, i.e. people like you and me, to have the opportunity to access in order for us to, in order for our complaints as ordinary citizens or as ordinary non-state players to be mediated or resolved. If I use the part of the world that I come from, which is South Africa, our domestic courts have been able to effectively mediate or arbitrate or resolve disputes that involve the government and the non-government players. In my background as a trade practitioner, I've sued the South African government many times, and successfully so. I would like to refer to one particular case or two particular cases where, in the first one, it was a case where what we call provisional anti-dumping measures or provisional duties were imposed against goods coming from outside South Africa and outside the region. I think they were from China, if my memory serves. And those provisional measures were introduced without the body responsible for trade, what we call ITEC, having given the opportunity to affected parties to make representations. In other words, the Audi alteram partem opportunity. And the courts intervened and said those duties have to be set aside because the process was not fair, in that interested parties were not given the opportunity to have a say before those duties were involved or were imposed. In another case, which has become a seminal case in South African trade remedies law and general administrative law, is a case where, again, our client, having benefited from a protective anti-dumping measure, wanted to keep it in place pending the conclusion of an investigation that was supposed to determine whether or not that measure should be extended. And the interdict was granted by the High Court. The Trade Authority appealed to the Supreme Court of Appeal, which upheld the measure, and the trade body then appealed to the Constitutional Court, which overturned the measure on the basis that the setting of duties is primarily an executive function, and the courts should be very careful in meddling in matters which are reserved for, for the executive arm of government. But I'm using these cases just to illustrate the fact that there is no direct access by private parties to the dispute settlement mechanism as currently configured under the AfCFTA doesn't mean that non-state parties are left without a remedy. And in fact, they are left with a remedy. Maybe in closing, I should say, my support for a limitation of access is on the basis that international trade is part of the extension of the country's international relations. And in some instances, narrow private interests may not necessarily align with the greater good that the agreement seeks to give and that the state seeks to achieve in its engagement with its peer states under that regime. And for that reason, my feeling is that it is imperative for us as private citizens to make sure that our domestic courts or municipal courts work for us to vindicate our rights, and then leave space for the state to work with us in our disputes with other states or players in other states. Thank you.
Thank you, Melu. And you're quite right. Tola, I don't know if you're on now.
I'm back. I'm so sorry. I don't know what happened.
No, not a problem. So maybe you can finish up and then I can just have one or two things to say. Yeah, please go on,
Okay.
Tola.
Yeah, so when you think of the way it was designed, the entire logic behind it was that you want to, one, allow every member state to have access to almost, in a way, the panel, right? But I think the second is that you want a negotiated settlement. So the idea is that you want all member states to work together, or at least disputing member states to work together to come to a conclusion. But you would see that the dispute settlement actually has a lot of, and I think too many times, and I say this consciously, we think only of the actual panel. So when you read the protocol on dispute settlement, you see that one of the options you have first is something called, there's mediation, right? Where the Secretary General of the AfCFTA can mediate between member parties that have a dispute. There is conciliation, right? There's arbitration, right? And you can select that you don't want to go to panel, you want to go straight to arbitration. And then there's the panel. The panel is basically all member states submitted two candidates. From each of the members, there's a roster of sorts, and you pick from that roster who your dispute settlement persons will be. And if you don't win the case, then you can also still appeal. There's an appellate body that exists. Now, why is this special? It's special for a bunch of reasons. One reason it's special is that it actually accords you a way to hold member states responsible for their action. But I think what makes it also stronger is also the remedies you get. So normally, before now, what used to happen is that if you want a dispute settlement case, in most tribunals, you get a financial benefit. So it's something like you want an award of $10,000. Well, the dispute settlement in the WTO actually tries to calculate the loss you have, but also give you a tool to actually retaliate. So you notice that the WTO says, for instance, and same with what the TSP has actually gone on to do, is that you actually can say, Nigeria actually has cut off my access to the Nigerian market. So I'm going to cut off the Nigerian access to the Nigerian markets. But what used to happen a number of times was that sometimes if you were a small country, it didn't matter, right? If you were a small country too small, it wouldn't matter. So what happened was you could actually do more than even retaliation. You could do something called cross-agreement retaliation, where you leave the agreement where the country did not breach and go all the way to a new agreement. And in fact, I worked on one of the cases like that in WTO called the WTO gambling case. And so the idea is that, and so let's use a real example. Let's say a country like, I don't know, I don't use any, but let's say Mauritius. Mauritius says, oh, Nigeria has cut off tourism from coming into my sector. The dispute settlement body agreement protocol allows you to say, I'm going to retaliate against Nigeria's intellectual property. So I'm going to start pirating Nigerian movies for free online. And what it does very interestingly is that it creates this very interesting tool where it's basically saying, I want to lean towards ensuring that members actually comply with what they agree to do. Now, one thing we've done that makes it very interesting is that things like the powers of big countries to boycott the appellate body has also been removed. So it's almost like everybody almost has the same exact access to the appellate body system like anybody else. Now, I think that my expectations are three, four things more generally. I think my first expectation is that it allows Africans to actually use the dispute settlement mechanism more. There's been a number of member states who have used it in the WTO system, not as much as they should be. My hope is that this actually also a chance to. So is that because there's actual trading happening within the AfCFTA area, My hope is that it allows us to develop jurisprudence. So for instance, right now, I just came back from Accra on Saturday when negotiating the digital trade protocol of the AfCFTA, which is supposed to govern e-commerce and digital trade, right? And one of the things that you see and you expect coming from those kind of conversations, right, is that member states will start to say things like, what does this mean for me, right? What's the implication of this for me? And the hope of the DSP is that you can use it as a mechanism to actually evolve international law. So for instance, today, digital trade is one of those things in global trading system that is not very evolved, right? And Africa has a chance to actually lead in how they interpret sections of international trade law through the dispute settlement body. Another interesting is that Africans by Africans, one big issue that is happening with the DSU used to be, and even most bodies used to be, that you'll go to the panels and a lot of the panelists were non-Africans, and the bills were always, you have to engage this very expensive consultant from the US or the UK or right, old international trade lawyers, and it was just incredibly expensive for member states. In this case, you have member states having submitted 2 panelists, almost all the ones I've seen the list, they're almost all Africans. So you're basically having a system where Africans, international trade law experts are the ones, and even technical experts. You see places where, in some cases, where something has to be something more technical, maybe logistics. You have someone who's a logistics expert make decisions on that. The hope is that you're actually creating a system that is robust and that allows member states to actually use it. Now, the last sentence I'll say on this is, on this whole question of non-state parties, private sector players having access, one thing we have to remember is that the AfCFTA dispute settlement mechanism does not take away the right of member states to use their local domestic courts and arbitration to resolve private disputes, right? And that would also keep evolving. But the hope is that you want a system where the AfCFTA law, the trade between the member states can evolve between member states using the panels, using arbitration, using conciliation, and basically that over time it evolves to something that is useful for member states. And I'm very hopeful about it, I'm very excited about the thoughts, and I'm actually looking forward to seeing how it functions over the next few years.
Thank you, Tola. I don't expect any less. You should be excited. You are actually in the deep end of the pool on this. Fantastic insights. But just before I come over to Ms. Olayede for private sector perspective, let me just piggyback off the comments my friend and brother here, Melo, made. Yes, some of us have this view that, and I think the last bit of Tola's comments touched on it, and it's interesting that at least efforts are being made to realize that African problems require African solutions. There is an issue, as far as I'm concerned, respectfully, with essentially cutting and pasting a dispute settlement understanding of the World Trade Organization, notwithstanding the membership of countries in the developing world like Nigeria of that organization, on the AfCFTA. I would have thought, knowing the infrastructural deficits that we have within the continent, the challenges that the ordinary businessman faces, even having disputes resolved within our justice system, that something just slightly more straightforward and easy to comprehend would have been put forward. But that is just me being the litigator that I am and trying to argue something that I'm certain may not go down well with Tola. But just to make that point. Now we've heard something that is, for me again, acting as a layman, so convoluted. You have the DSP, you have the AB. You're talking about a farmer somewhere in Karan Model, somewhere up north, who has 10 acres that he's planted tomatoes, and he needs to send them to Ghana, 10 tons or 10,000 tons. And there's some issue that results in his having to find a way to have his concerns addressed. He first has to find a way in a fractured system in a developing country like Nigeria to get the state to advance his cause, possibly with other traders, for want of a better expression. Mr. Olayede, you are, to put it simply, we now hear that traders can vie for the highest office in Nigeria, so it's not an appellation, it's not a bad appellation to give. In broad terms, you are at the top of the legal unit of arguably one of the foremost cement entities in Nigeria. I'm very certain that even before the onset of the AfCFTA, you've had cause to transact across borders within the continent. You've heard what some of the speakers, particularly our dear friend and brother Tola, has said. From a private sector perspective, what's your hope? I mean, if you haven't actually started, and from what Tola is saying, the negotiations are almost being concluded around the setting up of the dispute settlement mechanism. I'm sure there are other portions of the AfCFTA that he'll give insights to that are still ongoing. But speaking as a businessman, as a businesswoman, advising the conglomerate that you're so advised, what are your expectations? Are you comfortable with what you're hearing?
Okay, to be honest, you've actually raised a point that I had an issue with. You're telling me that as a private person, I've done business. So let's say, for example, I'm bringing in, like the farmer you said, his tomatoes. He's brought it to the border, or he's shipping it to maybe Ghana. Gets to Ghana, because of the port infrastructure, everything rots. He's waiting for 3 weeks to birth in Ghana. You're telling me he has to come back to Nigeria to start his process and then hope that his government will rise up and take the matter up for him? The eventual users of this trade is the private companies. That's what they're hoping, that the private companies will buy into it, and they will be the drivers, the real drivers for it, not really the government, but the private people. And for us to, start doing the business amongst ourselves. It doesn't seem as though it's going to work for me, because even here in Nigeria, let's be honest, when I go to court, I'm there for 10 years. So you're telling me I'll first start the process here, and then eventually it will get to Tola's team and everything. I don't know how that is going to work. So Tola, please, if you can,
Yeah, thanks. That's
Sorry,
Tola,
before you jump in, let Mark have a bite and then you can round up. Thank you.
Yeah, thanks, Tonya. Tola, don't worry, you'll soon be on. What I wanted to say, and we can build on this factual premise that that Tonya, gave us. So the tomato exporter now gets sued by the tomato importer, saying, guess what? You were supposed to deliver so-and-so to me at so-and-so time, and you didn't. So therefore, I'm entitled to costs of the repudiation of this contract. And then the other party, the exporter, says, well, guess what? You had tariffs that wouldn't allow me, we didn't anticipate these tariffs. So who's going to pay? And guess what? On the after, I'm not supposed to pay this tariff. So guess what? It's your fault. So who do we take this complaint to? So as Tola has ably pointed out, we can go and arbitrate about those issues. But ultimately, the barrier is a direct violation, if you ask me, of AfCFTA. So how do these entities express themselves? Now I take the point, and I'm just as excited as Tola is and Melu about what AfCFTA can do. I'm interested personally in the prosperity of the greatest number, and that's what AfCFTA is about. But there are mechanisms that we need to put in place, and one of them, in my humble view, is that we need to provide some mechanism, either domestic or trickle down from the treaty, that allows private entities to escalate the dispute to government so that government can then act. And not only must government act, there'll be timelines within which they must act, then bringing, triggering the DSB or DSU, call it what you will, into effect. So at that point, they can then escalate the complaint of the private individual to, the diplomatic level, where, the dispute can then be looked at. If you don't have this mechanism in place, then what you will find is that AfCFTA is somewhere up in the sky, and it's a pie in the sky, and no one is able to, deploy it in real terms. That's my 2 pence. Tola, over to you.
Tola, you're the hot seat now. I know you have very strong views about this, so let's hear them. Thank you.
So it's interesting, right? And why I laugh at this a lot is that during the negotiations, I was one making the arguments that Mark is making today. And it's strange that I have to the one on the other side today on the panel making the other argument. So what I'll try to do is give a bit of context about how some of these negotiations happen so that everyone understands how we kind of arrive at most of these points, right? So you're dealing with, so the thing is, when you go to a negotiation, right, and this is not just an African thing, this is all around the world, right? It's member states, sovereign member states who go to do negotiations, right? So Nigeria, South Africa, again, and you can look at NAFTA as another example. NAFTA is another example of that. You can look at the EU agreement. It's actually governments that go to do these negotiations. Now, the paranoia of governments is opening themselves up to litigation by private members. And the reason is simple. We're all last room, so I'll talk about it. We all know of the history of what's happened with investment arbitration and investment litigation over the last few years, and how just recently, about 5 years ago, South Africa actually basically removed itself from almost every kind of agreement that allows private member parties to sue it. And the reason was that you open this whole canister where private sector members could sue. And in fact, there's actually a case going on right now, right? The PNID case, right? Similar to that. And so governments are very paranoid about this idea of a private sector member state can sue me and there's no cap. Because what happens when they sue you, you go to arbitration. It's a private sector body, right? Or even an arbitration center. They actually almost have an unlimited filter on what they can do. And so member states freak out about that a lot. And so one of the reasons why you're not seen as much of member states being open to private sector parties suing them is because there's that constant paranoia of, I can't can this thing, right? This opens up a lot of things, that's one. But the second part you need to know is that, and so let's use that real example of the tomato case, right? So I'm a tomato trader, I farm tomato, I get to the border, I'm trying to get into Ghana, the Ghanaian authorities don't allow me bring this to the country, right? I'm stuck at the borders, and then what happens because of that is, the person who supplied to them sues me and says, you bring my tomato, I want to cancel this contract, all of that, right? There are 3-4 things that are important in that scenario. So there are 2 disputes. There are clearly 2 disputes in that scenario. There's a first dispute around the commercial details of the contract itself. What should apply? But there's a second dispute around what's the regime of law that should apply, in the sense of saying, what really should be the international regime? In the sense that, am I allowed to say Nigerian products doesn't come in? Now, for that more system, so what the AfCFTA system is saying is, for the more systemic issue, such as, can I get access of my products into Ghana or vice versa, the AfCFTA tribunal should deal with that technical dispute. But the more specifics of the commercial dispute of saying, my name is Tola, or my name is Shea and Co Limited, and I cannot get my product into, that application should be dealt with by a local court. That's kind of the distinction. Now, what kind of starts to happen is simple, is that usually what happens is that the mechanism is designed is that you do one of 3 things, right? Don't forget that there is a Ghanaian customs authority, there's an Nigerian customs authority, right? Who you can actually take to a local court, right? And so actually already you can take them to local court using the local court regime. So usually what can happen is that you can sue the Ghanaian authorities, Ghanaian customs, and say, see, and the reason is because almost every country has to ratify the AfCFTA into their local law. And so you can sue them saying, you did not comply with your obligations under this local law you apply, or under this law, the AfCFTA law of your country, and you can sue them. So that's one recourse that exists. The second recourse is that the 2 member states that have, the 2 private parties can go to a court system. The third that exists is that, and which is what I'm sure Mr. Lade prefers, is that you actually, as a group, can actually escalate to, and most countries already have this. They have AfCFTA secretariats, right? Nigeria has one, Ghana, almost every country has one, right? In fact, the Ghanaian one is actually in the same building as the AfCFTA secretariat. You can take it to those guys and say, see, there's a blockage here and you need to escalate it. The problem is that, and this is why there's almost separation of private sector and that, is that these things are a bit of politics, in the sense that usually what then has to happen is that this group has to get priorities and say, okay, I'm going to take it up to this person, I'm going to raise it to this issue and all that. Now, there are 4 conversations being had that I think might also be helpful. One of them is a convention about saying there should be an open forum for making submissions of this straight to the AfCFTA secretariat, and saying there's a blockage here, do that. The second big thing that's been discussed is actually similar to what you're saying, Mr. Mark, which is to say, can we create a system where private sector groups can actually raise issues to member states directly as a group? That's the second conversation being had. Now, the third that exists, which is something that I actually helped you for Nigeria, which I think every member state should build, is called a dispute settlement mechanism, a dispute remedies mechanism. Now, a dispute remedy mechanism is a domestic system that allows you to retaliate against the member states in a way to enforce your own rights. So an example is to say, if you're not letting me bring my goods into your country, I'm also not going to allow you to bring your goods into my country. The reason that's great is that it's faster. It relies between the power of a country unilaterally to use it, and you don't have to wait for a dispute settlement mechanism. So for instance, if somebody is dumping into your market, or if somebody is basically cutting price in your market, you can basically do a quick investigation within your country. And South Africa does this really, really well. South Africa does it really well. Egypt does it really well. You can do an investigation within your body, within your own country, and make actions almost immediately. Now, I'll be first to admit to you that this system today is not perfect for private sector players. But I think a lot of the reasons why it's not is that general fear of opening state party litigation to private sector members. The fear is that it opens them to kinds of to endless litigation. The cost of litigation is a lot higher for them. Private sector have deeper pocket. In fact, you can sell your lawsuits to a richer party and then say, you know, for instance, the PIND case, they already sold the lawsuit to a richer party, and that's why Nigeria is being sued. And so member states are very paranoid about that. And so getting member states in a dispute settlement, in a negotiation to agree to that kind of expansive clause is incredibly hard. They're going to say things like, what's to stop the richest man in the continent from suing me? What's to stop the second richest man in the continent from suing me, right? I don't have that much deep pockets, right? This man can sell his title to anybody else. So that's the dynamics of what you need to balance. But what I would say is that we also need to clearly, carefully distinguish between what I think are private sector applications and the actual things that systemically affect the system. The hope is that you have more things that affect the system, go to the DSP, and you have private sector groups also pressure the DSP. And I think there are more conversations happening. And the thing also to note is that the AfCFTA agreement allows for 5-year reviews. So in 2018, by I think next year, there's supposed to be a review of the AfCFTA, right? According to the agreement itself. And one of the things that I hope happens is that we get a chance again to push this conversation to say, should we expand this? And the reason why it's important is that you don't want to negotiate an agreement, and this is what negotiators face. You don't want to negotiate an agreement that member states don't sign. For instance, today, the protocol on trading services has still not been, the protocol on trading services, has still not been signed by member states. And the reason is simple. So member states have concerns about the expansive nature of that protocol, and have just refused to sign. And so what you also care about as a negotiator is that you don't negotiate something, because in the end, you're negotiating what member states are comfortable to cede. And so you want to be careful to ensure that you don't negotiate something that they will not be a party to.
Yeah, thank you, Tola. I will come back on the issue of services when we discuss how it impacts on the legal services sector. Before Melo rounds up on this point, I think Melo, you have a quick, okay, it's covered. Maybe we'll now go back to where we started from and end this round of discussions. Louisa, are you still on?
Yes, I'm on.
All right, fine. So, Louisa, just to tell you that the photograph that we have of you and the video, there's no difference. So, the rest assured. Yeah.
Well,
so, yeah.
Thank you.
So, any final thoughts? You've heard comments from the private sector. You've heard your colleagues. You've heard what is arguably a proponent of the AfCFTA, Tola, espouse his views. Mark has made his comments. Any final thoughts before we move on to other questions?
Thank you so much. Yeah, there was so much information there. Tola, you've been extremely vocal and excited about this, which I think is what we need. I do understand the concerns of the private sector, but as Tola mentioned, there are various mechanisms for recourse. And I think that implementing a system whereby the private sector can raise complaints that will be addressed by the Secretariat, by the DSB, should not be that difficult. It also highlights the importance of parastatals and industry associations within each country in terms of helping bring some of these issues to each government and to the forefront, and the importance in not being negative, but actually positive about the impact of the AfCFTA and building that confidence on the part of states. which has been eroded when it comes to dispute resolution. I think one big difference between the backlash against, for example, investor-state disputes in countries like South Africa, etc., is associated with the sense that these disputes are brought by foreign actors, foreign multinationals coming into Africa, and then getting massive awards against African states. The difference here is that we're talking about African parties trying to resolve disputes between African parties. And so I think the issues of leverage and that lack of confidence should be more easily resolved. One reason why some commentators think that African states haven't really utilized the WTO dispute resolution mechanism is that if there is a need for a retaliatory measure to ensure enforcement, African states have very little leverage in terms of actually hurting another state or another trading party under the WTO just because of the volume of exports and respective imports. Whereas within Africa, within the countries that are members of the AfCFTA, the issue of leverage is a little bit different because of the investment flows within the continent. So I think that the interplay of issues is different. I do think that we do need to build confidence on the part of states, and we need to educate the private sector in terms of mechanisms for redress when they feel that there's a grievance.
Thank you, Louisa. So just a final parting shot. One of the reasons why I've always held on to his argument about African solutions, I think you touched on it, is the challenge faced by developing countries under a WTO dispute settlement understanding. In fact, except it has changed, well over a decade and a half ago, I think was about the last time Nigeria participated as an observer, not a state party that had an issue to be resolved before the DSU of the WTO. I think one of the most active state parties in Africa is Egypt. I'm not sure what the situation of South Africa is, but I know that, you don't have that sense that African countries essentially dive in to have issues resolved under the DSU of the WTO. And I think, Louisa, you hit the nail on the head when you say the issues around capacity, they are not able to pull the same kind of weight that developed countries pull. China had a process called learning by doing. The Chinese would always stick their neck in, find out that the result is not what they want, and back out. But they've learned. But it's a very expensive process, extremely expensive. And this is why I kept on arguing for African solutions to African problems. It must be simple and straightforward. And I'm happy, Tola, you've made the point that, and reminded us anyway, that we have a 5-year time limit to hopefully continue to have these conversations around how effective the DSM of the AfCFTA is, to see if there are any need for tweaking here and there. So thank you. Please, I know it's totally not normal, but I really like all of us to give a round of applause to the panel. As we're rounding up, because I think we're pressed for time, comments have been made around the issues of services. I think Tola touched on it in his submissions, if you will. And it seems to me that, we all have to agree, legal services is our forte, at least for most of us in the room here. And I'm sure a lot of us would be interested to know, against the backdrop of the kind of restrictions that we all have. So for example, in Nigeria, we essentially follow common law. In other parts of Africa, they have civil law, and it all stems from our colonial past. They are Anglophone, they are Francophone. You have countries like Angola that have some Portuguese colonial past. So there are all differences in laws, languages, and what have you. Do you think, Louisa, that the liberalization of trade under the AfCFTA should include the opening up of the legal services industry so as to allow foreign trained lawyers essentially cross borders with ease in terms of their practice. What are your thoughts?
Well, as a Colombian Mexican who grew up in Kenya, practiced in the US, and is now back in Africa, I think I would be hard pressed to say no. But look, my view, I do think that this has to be done cautiously, and there are reasons why there is risk. But I do think that the whole purpose of the AfCFTA is to promote flow of services and flow of goods, and it is a very easy way to fill those gaps in resources and innovation and knowledge that may be felt in some countries where there is surplus, for example, in other countries. And you know, it would allow for a sharing of ideas in ways that right now are not possible. You know, the legal profession is traditionally quite conservative, as we know, even within regions where the common law system applies and where you have a lot of similarities in terms of culture and language, etc. This has been a challenge. If you look at, for example, the East Africa community, there should have already been in the adoption of the ability of lawyers to cross borders and say practice, a Kenyan practicing in Uganda and vice versa. But that has been very difficult to adopt in the region. And so I think my view is that we need to get over that mental hurdle, and then we need to focus our energy more on implementing measures to reduce risk. For example, risk in terms of ensuring that the practitioners have the relevant expertise in the country, perhaps by having them work under someone admitted in that country, or by allowing for feasible methods of qualifying under specific countries, rather than imposing very strict requirements, such as, for example, nationality, so that you can qualify to the bar. We would have to figure out ways of ensuring that the rules of ethics are actually enforceable against lawyers who are now crossing borders, etc. But my view is that enhanced competition is good, the flow of people is good, the flow of information is good, and I hope that we can get there at some point.
Thank you, Louisa. Tola, any thoughts?
Yeah, this is one interesting joke that I crack quite a lot, right? Like, because throughout the negotiations, one of the things that happened a lot, and the NBA-SBO participated very actively, the NBA also participated a lot. One of the things that I found very interesting was that lawyers were trying to protect their industry, and they're asking for liberalization, right? It was always very hilarious. You'd be like, oh no, liberalize the sector, but hey, by the way, don't open law. But oh, it was pretty hilarious. I think 2 or 3 things in my head. I think one is, and I say this, I think lawyers have a very unfair advantage. Lawyers get to write the laws for everybody in all the countries, right? And so they get to write themselves out of the laws a lot. So you notice that in almost every jurisdiction, in almost all of them, the NAFTA, think of the WM, think of the NAFTA, think of the EU. One sector that is not in a sense fully liberalized is actually legal services. In almost every country in the world, you kind of have to get some kind of local qualification to practice. It's pretty interesting, and it's a lawyer thing. Like lawyers, like, it's not like accounting. Accounting is a central standard, ACCA, you can almost show up anywhere in the world. But lawyers don't allow that. One of the arguments lawyers have made over the last few years, even on the WTO system and the DSB system, the AfCFTA system, is that the laws in every country has a nuance. And so you want people that are advocating or helping interpret the laws in these countries to have that local context. So it almost seems like where we are in most countries is to say, you can practice in my country if 2 things exist. One is that if we have a system of recognition of your law degree, and 2, if you write a local bar qualification exam. And it's consistent in most countries. You'd see it in most African countries have it. And that's kind of what the AfCFTA agreement has represented. Because what happens is that when you look at there's something called all the state parties submission, their representation of services. That's kind of what we've done with legal services. The same with the EU, same with NAFTA. I think that I'm fine with it. And the reason is simple. The reason is that I think that law in every country has a lot of context and has a lot of liabilities, right? If I'm going to depend on a lawyer's advice, and also because in a sense, we still haven't gone to the point of, because usually when you want to go to this whole system of having liberalization, you need to first go through standardization. So when we do in negotiations, with this conversation about standardization, harmonization, then liberalization, right? And so what happens with law profession today is that it's actually not standardized at all. There's common law, there's civil law, there's this whole argument of, oh, in my country, we use liberal rule a lot. Oh no, we use literal rule. Oh, there's this law from like 1988 that we all use. So I think because there's no, in a sense, a lot of standardization, we don't even believe in respecting the legal authorities and precedents from other countries, little less. So it's kind of harder to create some kind of standardization in the legal profession. And finally, today, I suspect that as things like AI and all those things constantly liberalize how we interpret law and how you can standardize the rules, that will be a conversation. I suspect that in the next 10 years, you'll have more of those kind of things happening, where people would say, listen, if you can do one simple exam, you can show up anywhere in the world and practice law. But I think that for us to get to that at all, we need to actually even sort out standardization, which is where the profession actually staggered behind everybody. And I think it's intentional. Lawyers are incredibly smart, but you know how they say, two lawyers, three opinions. We've consciously ensured there was no standardization, so that it's harder to like liberalize the sector. And genius, if you do ask me.
Thank you, Tola. Melo, any thoughts?
I must immediately declare my conflict of interest on this question. Look, there are universal principles, at least in international trade law, which do not depend on where you are trained or which country you come from. I mean, let's look at the dispute settlement system under the WTO. It's a rules-based system. All members of the WTO are able to access it, and practitioners who practice in those tribunals or appear before those tribunals are from all over the world. And what that talks to is the standardization that Tola has just mentioned. So in a way, I do think that at least at the philosophical level, it should be possible in some areas to liberalize services such as legal services. There is, of course, a danger that in areas where there isn't standardization, then you're putting clients at risk, quite aside from the fees, important fees that lawyers are supposed to generate. So I think over time, as we are establishing our unity as Africans in various fields and at various stages, I think the momentum should build towards a standardization and a universalization of the rules that we choose to apply to us. Thank you.
Thank you, Melo. Mark, no thoughts?
Yeah, I don't really. I mean, Tola and Melo have summed it up, brilliantly. There's a need for standardization. Certainly, as the integration continues, because it's not a one-day event. That's why it's not an event. It's a process. So as the integration heightens, then standardization will take place, and we'll probably move into the phase which we have. Which Tola mentioned about simply doing an examination within the individual countries in order to be able to practice within that country. And I mean, even in the United States, for example, if you qualify as a lawyer in Texas, you can't practice in New York until you do something similar to what we're saying now, since each of the individual states run, individual legal systems. So that's ultimately where we'll progress. But don't take away from the fact that, what Melu said, which is that when it comes to international trade, it's a rules-based system, meaning you don't have to have any specialist training. If you're a lawyer, you can interpret the law, you should be able to. So that's my 2 pence for now.
Yeah. Thank you, Mark. And I think that's I mean, it's a wonderful insight you brought to this, Melo, and I think it just reminds me of why the DSU of the WTO has been so active, particularly with developed economies. You have, I mean, the US, the UK, Brazil, they always find themselves there for one reason or the other, and it can only be because of certain certainty of the applicability of the rules. We hope that the AfCFTA will get to that point in its dispute settlement mechanism. Mr. Layade, I mean, again, as a businesswoman, I'll give you different appellations today, all relating to business. I'm sure you're concerned. So I'm a lawyer from Kenya, where Louisa is now. And there's a major issue where you are at the head of some major effort at exporting a product. You run into issues. And the first thing that concerns you is which law applies, Kenyan law, Nigerian law, where do you go to? There could also possibly be an issue of language. I mean, talking as a businessman, what do you hope to see the AfCFTA achieve? Tola, I'd like you to have pen to paper so that when next you go for your next negotiation, you actually have practitioners, actual people who are actually hoping to implement after air their views in your next negotiation round. So, I mean, what would you like to see?
Okay,
Yes.
it's funny that you mentioned that because some of the issues I think the AfTA is going to have is also the national language. Every country in Africa, we all have our own national, like our psyche, our language, our traditions, the way we do business. So for me, it would help if I could find another Nigerian there that understands, you know, there's a way, I'm sorry, we're Nigerians, there's a way Nigerians talk. And there's a way we explain things. You don't say a lot of words and the person goes, don't worry, I understand what you're saying. You know, when you start, you know what I'm saying? I understand exactly what you're saying. So for me—
Mark does that a lot.
So, you know, and there's a certain comfort in that because I already do not understand whether it's Nigerian law, Kenyan law that is going to do it. I also do not want to have to explain my objectives, what I want, what I would like to get, and have to sit down, break it down, you know, word for word. So the ability to be able to walk into Kenya and have a Nigerian lawyer that can work there would work for me. And I'm sure it would work for a lot of companies as well. Because as I said, every country has its own nuance. You know, there's a psyche, there's a way there's a language we all speak. There's our attitude to things. And I hear you about what you said about the international trade. He's right. If I can do like a qualified lawyer's transfer test, and I can, you know, set up in Kenya, and then Nigerians can come and meet me. And then, you know, it's easier for you to explain to me, this is how we're going to do it. So that when I'm explaining to my own principals, I'll be like, don't worry, the guy understands what we're talking. So, you know, that for me would be an issue, and it's something, Tola, you can look into.
Thank you. I mean, we could go on and on this. We're pressed for time, but as we round up, before we go to a quick Q&A, I know Louisa and Alainde, I know you're actually pressed to get on to other important business. Now, the Secretariat is an important tool, and this is my final question for this session, for the success of the implementation of the AfCFTA's protocols and rules. But there's something called the Council of Trade or something, the Council of Ministers of Trade. Tola, this is to you now, because I know you are, as I say, in the deep end of things. There are certain articles of the AfCFTA agreement, particularly Article 13, that situates the Secretariat in Ghana. And other portions of that agreement seems to give the Council of Ministers for States powers to determine the responsibilities of the Secretariat. In terms of, I mean, we're all looking for a process that is low on bureaucracy to prevent sluggishness in the implementation of the AfCFTA. Do you see the agreement, the articles giving the Council of States, of Ministers of States, power to determine responsibility for the Secretariat in some way whittling down the autonomy of the Secretariat in its overall intent to advance the cause of the AfCFTA? I mean, and I also say this against the background of what we now know They could be subject to some kind of review. But my worry is, this is a council of ministers for state, and these are potential ministers for member states of the AU or state parties of the agreement. So there's a lot of politics here now. Do you see this not impacting on the overall power or autonomy of the Secretariat? Tola?
Thanks. That's a very helpful question. And I think before I even start to answer the question, I think I'll just double click on something that Ms. Alanya said. And I think that's important, right? One of the things that I do today in my company is actually helping you set up in every African country. And the reason that's important is, and I think that, and I'm happy because I was speaking to a group of internationalists and lawyers, is that one of the things I think lawyers need to start to do is actually start to take all these AfCFTA rules and actually make it have meaning for their clients, right? And for even private sector groups. I think that one thing you don't realize as much as possible, and I realize it when I'm in this kind of rooms, is how to a non-lawyer and to a non-technical person, all of this can look like a black box. And I think one of the things that lawyers have to start to do is to start to take all these pieces of things or balance and start to say, this is what this means for you. And I think that in the next 10, 12, 15 years, I think the success of the AfCFTA, more than anything, depends on all that kind of work. And for instance, my platform today at Norbis helps you register a company and get licenses in every African country. The question is, and law firms like, I can see the ALN logo all around this flyer, right? Things like that, initiatives that ensure that I can say I want to expand my business, or I can say I want to start my company, or say I want to do business in this country and get good access to the rules that exist for me will become incredibly important, right? Because the AfCFTA in itself is just a big tool. It just gives opportunity and access. But to actually milk the benefits of it, businesses, lawyers, actually private sector groups actually have to try and use that system for it to work. That's one. Two is this. I'm touching on your question. Everything goes back to one simple principle, something called the right to regulate in international law. The right to regulate is that countries have full sovereign power over their territories, full sovereign power, right, over their territories. When a country enters into an international agreement, it technically cedes part of its powers by its own consent to that international body. So when I say I'm a UN member, I'm a WTO member, I'm an AfCFTA member, I'm intentionally ceding a portion of my sovereignty. But the thing is that sovereign power in the end still evolves back to me. That's what the law says. Now, when you think of the dispute settlement mechanism, or even the negotiations generally, you know, negotiations were done in 3 stages, actually, maybe 4 stages. There's something called the task force. The task forces do all this work of saying, what exactly is the draft of the agreement? It goes generally to technical working group. From technical working group goes to the negotiating forum, and then it ends up on the body you call the African Ministers of Trade, AMOTS, right? And so every draft agreement you saw actually went through the stage, right? Where a technical working group put it together, it went to the negotiating forum, and then finally was endorsed by the African members of states before it even went to the Council of Presidents and was endorsed in any country or ratified or whatever it is. And so the role of AMOT, more than anything, is to create this whole system where constantly member states are saying, I am the one giving these powers, and I'm the one determining what I want to accept. Now, it's better to look at the AfCFTA is supposed to be, and the same with the EU. If you want any of these things to work, you need it to be a members-driven organization. The moment it starts to become a commission or a secretariat-driven organization, it starts to fail. And you can look at what's happened with the EU with the UK's withdrawal from the EU. One of the biggest arguments against it was the EU Commission is making rules for us, which was a lie, because what was happening basically was everybody will go to the EU Commission and decide together. But once people stop seeing that it is member states that are making decisions themselves, if people start to think that it's a secretariat somewhere that's imposing rules on us, what's happening is the members start to feel like, am I caught in this trap? And so one of the reasons why those things were put there was to actually capture for the sentiment of the time of saying, see, it's the member states that are from time to time deciding how they want these things to go. And the reason is because no matter what the secretary wants to do, if the member states all say we're not moving in this direction, you can't move in the direction, it's just what it is. And so the idea is that you want to negotiate an agreement together saying this is what it is, and you want the secretary to support them in achieving all the objectives of that agreement. You want the secretary to give them capacity support where necessary. You want the secretary to do the coordination work of future negotiation, the coordination work of getting everybody into the room, the coordination that everybody has all the context from time to time. But you want to ensure that at every time, it clearly shows that the flow of sovereignty comes from the ministers of trade who represent the sovereign rights of all their countries. And that's why it's there. Does it limit the power of secretariats? In actual rules, no. Because what happens is that the Secretary Minister of Trade meets from time to time, but it's not as frequent enough to actually cause it. Usually they do more systemic work. So it's more things like, should we add a new protocol? Should we go in a specific new direction? It's more systemic type things that they spend their time. But the truth is, the day-to-day is actually almost managed entirely by secretariats. In fact, even negotiations, where is the negotiation going to hold today? Where's the meeting going to hold? What are going to be, what documents will, almost all that work. The truth is, the way to think of the secretariat is almost to think of the chief of staff to the president. In all rules and purposes, the minister and the states are the ones that are supposed to have all the powers. But in real sense, what the president signs is what the chief of staff brings before you. And that's the kind of power the secretariat has. It has so much powers in determining, and because of how powerful it can become, because also don't forget that when you look at the AfCFTA, the person you see all the time is the secretariat, the secretary general, the secretariat. So it's very powerful in shaping the AfCFTA. Shaping, for instance, there are two things they're doing now. There's something called the guided trade regime, where you allow member states actually try to do trade amongst themselves. All of that initiative is driven by the secretariat. All the idea of coordinating all the member states done by the secretariat. And so that's how you want to think of it. Yeah.
Okay. So in your view, it doesn't derogate the powers of.
It doesn't. Yeah.
Louisa, any thoughts on this?
Thanks. Tola's response was very comprehensive. I was going to make the same pitch, basically, which is that in order for this to work, there has to be ownership and buy-in from the relevant states. So I don't think that there would have been a different mechanism that could have been implemented to supervise, I guess, the strategy and the direction of the Secretariat. So I would agree with Tola.
All right, thank you. So we're winding down. We've come to, so there's something called the power of the moderator, and I'm exercising it. For the benefit of my panelists, I can see Tola is already drinking water, so you can imagine the amount of work they're all being put to. So we are now at Q&A. As at last count, we were about 112, 111 persons online. Larry, I do not know if we have, yeah, okay. Sorry? We have questions. Okay, so how do we go with that? Maybe you can ask the questions. So we'll just take approximately, what, 3-4 questions, so our panelists can go about the business. Yeah. So.
Thank you, sir. I understand there are questions in the room as well, but we'll just read some of our online questions. The first question is, there has been seeming minimal interest in the role of economic zones in achieving the goal of the AfCFTA. What is the future, and how can the extensive cross-border trading and cooperation be achieved?
Can you please also state who, I mean, if there's a name or something?
So this question is from Kayode Nisi Joshua.
Okay. Sorry, let's do 2 questions, and then we can take maybe 3 from the audience here, and then we'll call it a wrap.
Okay, so I'll go to the next question. With the proliferation of tech, some of these closed lawyer issues will quickly fall away. What are we lawyers going to do with the tech reality?
I think Tola mentioned on the potentials of technology having an impact on the issue of standardization. But maybe Tola, I just want to quickly answer that question before we go to the audience here. Yeah.
Sure. I can touch on the 2 questions very quickly. So on the issue of the economic trade zone, there's actually a lot of cautious conversation about it. So it's the thing with negotiations is, and with coming up with an agreement for 54, don't forget there are 54 countries, 41 currencies, maybe like 7 official languages. So it's actually very complicated region to be making a rule for. The problem is that everybody has different rules on how to look at this thing. So I'll talk about economic zones more generally. Egypt is very pro-economic zone. Egypt has a lot of it. If you've ever been to Egypt, Egypt has a lot of economic zones, and Egypt is very pro-economic zones, right? South Africa is not as much pro-economic zones because South Africa doesn't have as many economic zones. But the debate is this, and this is where you want to have the real conversation. The real conversation is this. when you create a free zone in your country, you are creating a kind of mechanism for ensuring that exports is made easier. So you want to create a mechanism where you want to create an area where tax is lower. You know, all those, you almost are suspending the rules of the country in that area. Tax is sometimes lower. In fact, in some free trade zones, you don't even pay taxes, right? All those things. So the debate is, if you create a material in a free trade zone with all those preferences, should it be allowed to compete with the things that I made in my own local market? So let's say you assembled a car in a free trade zone. You didn't pay taxes. You didn't pay any import duty on the metals. Should I allow you compete with my own car that I produced in Anambra, right? Where I pay taxes for bringing everything in and all that. And that's the big debate of economic zones. Member states have different opinions on it. There is actually an inbuilt negotiation. Inbuilt negotiation means an ongoing negotiation on it, currently happening. Nigeria has moved positions quite a number of times. Nigeria at first was very anti-free trade zones, being a part of the bodies that count as AfCFTA Secretariat. Right now, it seems like Nigeria is moving towards it with the rise of a lot of economic free trade zones. But it's a debate. But I just want to make you understand that the debate is really this question of, is it a level playing field if I allow a... So one of the arguments has been, if you create something in a free trade zone, when you bring it into the main AfCFTA area, you should pay taxes for that difference so that you have a same equal opportunity like everybody else. Some other people have argued and said, no, not really. You should be able to do it. And that's the debate going on about it. So there's actually a conversation, an active conversation on free trade zone happening. But the debate is, what's the way to solve it? Do we solve it towards saying free trade zones are part of the AfCFTA Secretariat automatically? Or do we say pay an extra export tax for bringing your thing that you created in free trade zone into the AfCFTA main area? That's one. And that's the debate. I don't think there's an answer on it here. There's no scheme about to solve it. Members start to negotiate what they think is preferential to them. But it's a debate going on. And if you probably have if you have a way about you solve it, I advise that you write some good material about it. Probably won't push it through your negotiation body of your country. But it's a big debate for countries right now on how to address that issue. On the issue of tech, I do agree. There's a company called Do Not Pay Law in the US. It's an AI. It basically can do everything. It can help you get cheaper tickets. It can help you negotiate your flight tickets. It can help you do almost all the legal day-to-day things you need to do as someone that needs a lawyer. The even arguments are now it can go to court on your behalf and make an argument on your behalf. There's also ChatGPT. I'm sure I use ChatGPT a lot in my day-to-day life, right? To like summarize notes and all those things. And today you can almost ask ChatGPT to tell you a full argument for a case under Nigerian law. You can tell it under Nigerian law, what's the argument for this? And ChatGPT will make a full legal argument and brief of what's possible. You can even tell it something like, I don't know who wrote this material. Tell me who you think wrote. And it will tell you, I think that Mr. Mahmoud SAN wrote this material. And it will do an analysis of why he thought that. So the thing is that it's getting more complicated and a lot more robust. And now, I don't think we've gotten to the point of intelligence yet. What we're getting is a world where the AI is getting a lot better at using materials to make new judgments. But I think there's a next stage after this where AI actually can think for itself and evolve. And when you get to that point, you almost can get to a court case where you'll be like, it's me, Tola, appearing for the defendant, and you'll be like, it's me, AI, appearing for the respondent. And I think we'll get to that point eventually. And I think as those things happen, lawyers will have to find a new way for what their use in the system is. I think lawyers are best at three things. And lawyers are best at solving complicated human problems. I think machines and AI are not great at that. The legal nuances, lawyers are great at that, humans. And I think the second thing lawyers are incredibly good at is basically using law to organize society. And that's something lawyers are incredibly good at, all that context. I think the third thing that lawyers are good at is solving hard problems that no one has ever tried to solve before. AI and tech usually needs a correlation to solve a new problem. Lawyers actually can think out of the box. And I think that as we see more standardization, that's what you'll see. You'll see a world where the systems will look similar, countries will adopt similar laws, or you'll see that for solving new problems, for solving societal problems, you lean on more lawyers. And I look forward to those kind of work. And I think that even within the AfCFTA, that's what will start to happen, where common problems outsourced to AIs and machines to solve, and we spend more of our time solving more sophisticated problems. And I hope that's what we get as a country.
Thank you, Tola. So because of time, we'll just take two questions instead of three, please. What we will do, Larismi would receive questions, even the ones that have been made available to us virtually, so that we can forward to the resource persons, and whatever responses are, please just include your email addresses and they will definitely would forward the answers to you. Okay, before we go to the two questions, Melo has something to say.
Thanks, Tony. I just wanted to add to what Tola was saying in relation to special economic zones. I think it's part of the problem that exists even in the under the WTO system, where members of the WTO are permitted to use subsidies in certain circumstances, but otherwise are not. And where you then use subsidies to the detriment of other members of the WTO, those members who receive subsidized goods have the right to invoke remedies that seek to remove the adverse impact of the subsidy that attaches to the imported item. So I think that's the one level at which you deal with special economic zones. But there's also another level which is slightly more complicated in that, and that's what, for instance, we are confronted with in South Africa, that many countries in the East and in the West have used state support to develop industries and grow their economies. At what point do you then say to a state, stop supporting industrialization or stop supporting growth in a particular area of your economy? And at what point is that good for the continent? At what point is that bad for the continent? So I think it's something around which a lot of thought has to, to still, be done. One of the frustrating things in South Africa, for instance, that when we deal with, for instance, goods originating from China, which we know are subsidized, and as an affected industry, you want the state to intervene and bring what is called a countervailing duty against those goods. You find a general, it's not written, but you find some reticence or reluctance on the part of the state to act against China, because South Africa is arguably a developed country, but its society is still in a developing phase. China is in a developing phase. Why should we not, allow Chinese to support their industries? And likewise, why would the Chinese not allow us to support our industries? So that's a bit of a more nuanced, more, ideological, more political question. But off bet, both under the WTO system and I think under the AfCFTA system, you have a right to mitigate the harm that a subsidized product causes to your domestic industry. Thank you.
Thank you, Melo. Good insight. Larry, two questions. If we have any within the audience, then we can wrap up. There's a hand there.
Okay.
You can give her the mic. Introduce yourself and ask your question.
Good morning, everyone. My name is Veronica Obi. So I wanted to ask so under the AfCFTA agreement, there are several protocols, some of which are still being negotiated. I think one of them is the protocol on competition policy. And I was wondering what types of anti-competition state practices should negotiators have in mind when negotiating this protocol? I think off the top of my head, I can think of perhaps when liberalizing trade and then freedom of movement of goods and people, you can anticipate, for instance, if certain states do not keep their labor laws up to par, you find that could attract certain big companies to move their companies there, and then in exchange for lower or lesser less stringent rules on labor practices. So what kinds of anti-competition state practices should the negotiators have in mind while they are finalizing the policy, the protocol on competition for adoption? Thank you.
Louisa, any thoughts?
Thanks. I'll confess that I actually haven't had a chance to review the recent protocol on competition. I think Tola would probably have a better sense here. But as someone who did antitrust and competition law for a long time, I do think that these ground rules are very important for a healthy and vibrant private sector across the continent. It is important to regulate the conduct of businesses, and especially those who can rise to the level of monopolies, etc. We have seen the actions that the DOJ and the European Commission have taken against big players like Meta and Google, etc., in trying to split up or reduce some of the power that these companies have. So I do think that having a set of ground rules on competition law that fight, restrictive trade practices and other conduct within the continent is important to a healthy regional economy. But I'll let Tola address some of the more technical aspects of the protocol.
Before Tola answers that question, let's have the second question so he can do a wrap up of both.
We have
Any other?
one more question.
Okay. Sorry, there's a hand here.
Okay.
All right. Yeah.
Yes, I had read around the states that are the pilot states.
Name.
Ayokunle Adetula. I read about 7 states that are the pilot states for AfCFTA, and from those 7 states, it seems it's only Egypt that is one of the at least biggest 6 economies. My interest is to see how soon will this pilot phase get out, and I guess the complexities that the Commission is would always want to see would always come from many of these big economies. So my question is around when will this pilot phase end, and which of the other big economies among probably the first 6, 7 would actually come into the next phase? Thanks.
Tola, maybe you can start with the second and dive into the competition question.
Thanks. So let me make some clarification on this. It's called the guide, and thanks for bringing. It's called the Guided Trade GTI, Guided Trade Initiative, right? So let me make some clarifications about it, right? Because for context, member states choose whether they wanted to be part of that or not. So basically, what happened was this: the FTA agreement had been negotiated, right? You now have to get to the actual implementation of the agreement, right? And so there's this whole question of how do we even start to implement? Do you start to say that there's a special track for AfCFTA goods? What does that mean for customs? There's all that conversations happening. And so one of the things that the directorates on customs decided to try was something called a guided trade. So the idea was, let's even try and send products among the countries using the AfCFTA, right? So there's something called the AfCFTA tariff book. It basically sets out, and I think it has an online version, it sets out all the tariffs that all the member states have agreed to, all the elections they've made on different trade. And so the idea was that let's even try. So it was an open call. If you're a member state, you think you're ready to try and experiment, pick one product that you're going to use for your guided trade, and let's try and send something. I think a number of people chose tea. I don't know why they all chose tea, by the way, but there were like 7 member states, I think Rwanda, Kenya, Egypt, a bunch of them, right? So Kenya is also a big economy, by the way, just for clarity. So South Africa was there, Kenya was there. I think Egypt chose ceramics or something. Everybody chose all kinds of things, and they tried to send it. And so basically it was an election. What happened afterwards was that member states started saying things like, well, I want to be part of it, but it was actually an open call to everybody to participate. I think they're trying to do a second pilot in like a number of weeks again, another guided trade. But it was just basically a way of saying, let's try and do this trade and see, because we talked about it over and over again. We talked about all the problems, because what happens over and over again, people spend time talking about all the problems. This is what might happen. This is snacks. So it was like, you know what, instead of just talking, let's actually pick one product in a country and actually try and send it. And let's see what happens. And so, for instance, one thing that happened in the guided trade was that we saw situations where a member state refused to honor a tariff, right, of a country that they had agreed to in the agreement. And there was other clarification. We saw cases where customs officials didn't even know some of the tariff lines. So there's a bunch of things, and you throw up all those issues and trying to resolve it. So that's what the guided trade was about. It was more just let's actually do one real trade simulation and see what happens. That's basically what it was. And it's open to all member states. I think they're doing a new one. and almost all member states will be part of that. On the competition policy, so the three things to note, well, I should stop saying three things to note, but two things to note, right, is that there are a lot of committees negotiating different things in parallel, right? There's also a lot of built-in negotiations happening. So there's a committee on services, there's a committee negotiating intellectual property, competition and investment. There's one on digital protocol, where I am on. There's a bunch of them, right? And then usually what happens after the zero draft, it goes to the member states and goes on and on. Now, I can, some of the leanings of the protocol on competition is leaning towards a number of learnings from what we've seen from the EU and the US, right? The US and the EU systems have some of the most evolved systems. Nigeria is also making a lot of strong inputs. South Africa has some of the most evolved competition law policies on the continent. Same with Egypt. So they're also making, they're members of that committee and they're making deliberations. I don't want to prejudice what I think the committee will come up with when they're done. But needless to say that there's a lot of debate around how do you even determine the threshold of competition, right? At what point do you say, and even things like a dominant position, what does that really mean? So there's a lot of debate about that happening, about what does dominant position mean, especially in the context on an African continent basis, right? It's easy almost in a country, but what does it mean? Also, the big debate also is, do we set up a Pan-African competition commission of sorts, right? There's something that exists in Gambia today, but what should the reach of its powers be, right? And there's a lot of conversation happening about that. I suspect that in the coming days, we would see more of the drafts of what that looks like. But the truth is that there's a lot of, and the truth is, you're bringing several member states who have several definitions and several things they want to protect. If I am a country which is very advanced in my development, I have an instinct to want a more restricted competition policy. So you're seeing all those debates happening, and I think they will come to some kind of middle ground at some point. Yeah, and I think there'll be a lot of built-in agenda where they'll do future negotiations on specific issues.
Thank you, Tola. And Tola, please. I know, we'll put you on the spot. You would be joining us in session A. So please, I know you just had a bottle of water. Try and get another bottle by your side. The questions will be coming in fast and furious. Distinguished panelists, I really want to thank, on behalf of the chairman of our firm, of council, my learned brother Silk here, and the members and staff of Aluko Oyebode for what is arguably fantastic 1 hour plus spent on discussing the threats and opportunity of the AfCFTA. Please give them a round of applause. Louisa in Kenya, thank you so much. I know you're under pressure. You can now make that, I'm sure it's related to a brief appointment or instruction. And we really do wish you well and thank you for your time. Tola, our brother, you'll be hanging on. We really have to squeeze out everything from you. And you're so giving, and we're really grateful for the time you spent with us. Melu, I'm sure after this discussion, in addition to the lunch we have, I'm sure Mark is arranging dinner. So you get a taste of some of the delicacies we have tonight. Thank you so much for your insights. Our big sister, Ms. Aluko, what you don't know is I can only imagine the number of calls that she has not answered in the last couple of minutes here. We're really grateful. We will quote unquote release you in the next couple of seconds. My brother Silk, well, you and I are here together, so there's nothing to say about that one other than to. So thank you for your passion in leading the international trade team in the firm. Distinguished colleagues, this brings to an end session 1, panel B. Stick around. Larry Simi, I'm sure, is going to ensure that we are all entertained. Larry Simi, don't tell me if I'm telling the truth or not, but
you're correct.
For session 2. Thank you so much. A wonderful round of applause once more for the
Thank
panelists.
you.
I think, yeah, Larry Simi.
Thank you very much, Mr. Kukubo, SAN. Thank you, everyone, for your time. I'm sure you've had a great time so far. Please put your hands together for yourselves. And please let's put our hands together for our online audience. And then those speakers who have been waiting online for a while now. Thank you very much. Mr. Kukubo, please, we'll have to, yes, please. Thank you very much. No, after. Thank you very much. Okay, so we're just going to move very quickly. No, please stay. We're just going to move into the second panel session. We've had some of our other panelists waiting online, and so we're just going to invite them. We've also had Mr. Seun Ogundolapo in the room all morning. Thank you so much, sir. You could please mount the podium. Let's put our hands together for Mr. Seun Ogundolapo. Let's also put our hands together for Professor Jonathan Aremu, who's joining us online. Let's put our hands together for Mr. Francis Anatogu, who's also joining us online. Mr. Daniel Ungumi, please let's put our hands together. He's joining us online. And of course, the only woman in the room, Mrs. Olusheye Alayonde, please let's put our hands together for her once more. And to our very own Mr. Mark Modi, SAN, who's going to be moderating this session. Let's appreciate him with a very warm welcome. Thank you very much. So this takes us to the next session. Have a great time.
Well, welcome to session 2. I'm grateful for your time and your patience. I thought we had a fantastic time with the first panel. And, we still have Tola to turbocharge the conversation when required as well. So thank you so much for your patience and your time. I have a distinguished panel with me this morning. Maybe we should proceed from those online. We have Mr. Francis Anatogu. We also have Daniel Ngumi from ALN Kenya, Luisa's colleague. And then we also have Professor Jonathan Aremu. I'll just briefly read the bios of our distinguished panelists succinctly and as quickly as possible. So let me start off with Professor Aremu. So Professor Aremu, we've done some introduction about him before, but let's just do this briefly. He's a professor of international economic relations and a former acting vice chancellor of Covenant University, Ota, Nigeria. He's a consultant at ECOWAS. That's the Economic Community of West African States on Common Investment Markets, Abuja. He started his career, a very successful career at the central bank, where he rose from assistant economist in 1980 to become the acting assistant director of research before voluntarily retiring. At the national level, Professor Aremu was among the experts appointed by the federal government in 2012 to develop a trade policy for implementation in Nigeria. In 2018, he was a member of the technical working group on the Nigeria Impact and Readiness Assessment of AfCFTA, and is currently a member of the National Action Committee on AfCFTA. He was also appointed a national consultant of the UNECA, that's United Nations Economic Commission for Africa, that developed the AfCFTA national strategy for Nigeria, and is also a coordinator in one of the main technical working groups established by the federal government that developed the National Development Plan for 2021 to 2050. I mean, I could go on and on. It's an extensive CV, but all I can say is, Prof, you are welcome. God bless you, sir. Our next panelist that I want to introduce is my friend and colleague from Kenya, Daniel Ngumi. Daniel Ngumi is the co-managing partner of ALN Kenya, Anjawala and Kana, which is generally considered the leading corporate law firm in Kenya, and is the largest full-service corporate law firm in East Africa. Daniel also heads the firm's tax department. He specializes in regional and international tax law and has extensive experience in tax disputes and tax transactional matters. Daniel provides ongoing tax advice on matters affecting clients across various industries, including the financial sector, power, energy, infrastructure, oil and gas, and FMCG, amongst others. He has advised on a variety of matters from debt and equity transactions to mergers and acquisitions. Daniel chairs the Law Society's Tax Committee and is a regular speaker at local and international conferences. He's ranked by Chambers Global as a leading tax practitioner, and he's a qualified CPA and also Bachelor of Laws degree from University of Nairobi, a postgraduate certificate in tax law and a master's law degree from the University of London, UCL, and Queen Mary. Our next distinguished panelist that I would like to introduce, one of the online panelists is my dear friend, Francis Anatogo. Francis is the Chief Executive of Trans-Saharan Limited. Until recently, he was a Senior Special Assistant to the President of the Federal Republic of Nigeria on Public Sector Matters and the Secretary of Nigeria's National Action Committee on AfCFTA. In that role, he coordinated the establishment of the Nigeria National Action Committee for the implementation of AfCFTA and championed the development of Nigeria's strategy for implementation of AfCFTA. He was also the secretary of the Presidential Committee that conducted impact and readiness assessment and stakeholder engagements that resulted in Nigeria joining AfCFTA. Prior to joining the public sector, he advised organizations in the energy and communication sector on strategy, operations improvement, and project management. In another life, he was in the oil and gas sector and was so with several international organizations in diverse roles across the exploration and production value chain. He has a bachelor's degree in engineering, mechanical engineering from the University of Nsukka, and an MBA from George Business School, University in Cambridge. He currently advises businesses and governments seeking access to international markets. Finally, last panelist that I'll introduce, because we've already done so for Melu and Mrs. Alayade. Our final facilitator that I'd like to go through his bio very quickly is our dear friend Sheo Ogundolakbo. He is currently the head of trade, products, and finance at Stanbic IBTC. Everybody knows that they are a Pan-African bank, international bank, some would say, and is a member of the Standard Bank Group. He has over 21 years cross-sector experience in trade operations, international trade finance, transactional banking, and transaction structuring. Sheo is a seasoned banker who has worked in both local and international banks. Aside from core banking, he's been involved in capacity building and training for both staff and clients of the organizations he's worked for. And he's a graduate of management and accounting from Obafemi Awolowo University. He proceeded to do an MBA at the Swiss Business School, where he was awarded an MBA in June 2019. He's a member of various professional bodies, including the Institute of Chartered Accountants of Nigeria, beg your pardon, Chartered Institute of Stockbrokers, CIS, and he was admitted a stockbroker in 2011, licensed to trade on the floor of the Nigerian Exchange Limited. Can we just give a round of applause for our seasoned and distinguished panelists? So this panel is going to be looking at some of the practical challenges, that we perceive impact upon the implementation of AfCFTA. And I'll immediately throw a question to Prof. And my question, Prof, based on what you've seen, can you point to structures that need to be on ground for the full actualization of AfCFTA? Or does it seem to you that AfCFTA may be seen as most member states as an event rather than a process? Could you give us your views, Prof? Sorry, I'm going to throw the question around. So Daniel, sorry if I'm catching you on the hop. I'd like to hear your comments, and Francis, can I hear your comments? What do you think?
Sure.
For ease, I'd repeat the question. Based on what you can see, can you point to structures that need to be on ground for the full actualization of AfCFTA? Does it seem to you that AfCFTA may be seen as most members as an event and not a process?
Sure. I mean, I can kick it off and Francis can also jump in. So to begin with, I think the key aspirations of AfCFTA are to gradually eliminate tariffs. I think they say on at least 90% of the goods, and to reduce barriers to trade in services. And the aspiration of AfCFTA is effectively to ensure by the year 2035 that Africa's income increases by about 450 billion US. It had been referred to at the earlier conversation about the steps that are being taken by member states. So in 2022, a number of countries in Africa, I think there are about 8 of them, came together in order for them to undertake the pilot program, also referred to as the Guided Trade Initiative. I think the countries were from 5 regions in the continent: Cameroon, Egypt, Ghana, Kenya, Mauritius. I think Rwanda, Tanzania, and Tunisia are also involved. And the idea was really to focus on a number of areas, what they were calling the priority areas, which were going to effectively be the areas where we would see through the Guided Trade Initiative an initial pilot project for the commencement of how this is going to work. Beyond that, it would be rolled out to a number of other countries thereafter, and finally expanding to all the countries that are part of the AfCFTA initiative. The idea for 2023 is to then move on from the Guided Trade Initiative and go to trade in services. The 5 priority areas, as I understand them, will include tourism, transport, business services, financial services, to mention a few. And therefore, the idea has always been to progressively work towards the outcome where we would effectively roll out the project. So coming back to or roll out the initiative across the African continent. So coming back to your question, is it seen as an event? Is it seen as a process? It is quite clear, in my view, that it was never going to be the case that the tariffs could be eliminated in one shot. I think it was going to be a progressive achievement. I think also the aspirations of AfCFTA are progressive in nature, in the sense that over the course of the next few years, each of these steps will be initiated and effected. And I think it also goes to point out to the fact that when you look at the African overall agenda, the intention is that over the course of the number of years until 2035, these steps would be taken. So I do think that we are seeing a number of countries that are going to be initiating this and getting involved in terms of achieving it. And I do think that the whole process is really going to be one where a lot of work will go over the course of a period of time. So therefore, not an event, much more of a process, and one that is going to be progressive in nature.
Thank you, Daniel. Francis.
Thank you. Good afternoon, distinguished ladies and gentlemen. Thanks, Daniel, for kicking that off. It is not an event. I lack the words because process doesn't do it justice either. Because what we are seeing with AfCFTA is a big project that will define how we trade, how we even live. It's probably going to get to as close as being a way of living over the next 20, 30 years. And why do I say that? I mean, when you're thinking about the requirements for what you call full implementation, there are the institutional requirements, there are the process requirements, you've got the legal regulatory requirements, and also quite important, some kind of mindset change or changes that we need to see for us to get to that destination, which you alluded to. The institutional requirements, a lot of them are already in place. You've got the AfCFTA Secretariat in Nigeria and in many other African countries. You've got the national implementation committees. What needs to happen going forward is a link between, at the Secretariat, for instance, now you've got all sorts of committees regionally focusing on negotiation and increasingly trying to wrap their heads around how to implement this program. So coming down to the national level, the implementation committees are made up of people from all economic sectors, really. Beyond the implementation committee itself, you've got other institutional requirements, like to apply the rules of origin. You've got the designated competent authority, which in Nigeria and many other African countries is the Customs Authority. Beyond that, the first panel talked about dispute resolution. One key thing I heard, there's this statement about African countries not shying away from going to WTO for dispute resolution. Yes, one is the expense, but the other thing is that they don't have, apart from I think about 4 countries, many countries, including Nigeria, don't have trade remedies institutions that would methodically articulate what they would take in the manner that is prescribed in the rules. So that's the Trade Remedies Authority, which Tola and his team tried to put together. Is another institutional requirement, which hopefully should take off soon. And that's just the institutional element of it. On the process side of it, the trading process, because this is a preferential trade arrangement with specific rules, process for rules of origin and all of that. Beyond that process, you've got the legal one. There is you've got to domesticate the agreement. So it needs to align with your domestic body of laws. You need to come up with new set of laws and policies to drive competitiveness, to drive focus on specific sectors that are specific products and services that you want to push as a country. Beyond that, the mindset. So this is like, we in Nigeria, we all familiar with the Local Content Act in the oil and gas industry, and it didn't come easy. So imagine a local content, not just for a sector, but across sectors. So there's a lot of work that needs to happen. Now, part of the rules of origin means that for you to meet the rules of origin is you need to look and seek out suppliers in other parts of Africa. That requires a mindset change. So there's a lot that needs to happen, and all this, and we're focusing a lot more on trading goods. When you come into trade in services, you now need to start looking at mutual recognition agreements and other cooperation type agreements to simplify trade, to simplify movement of people across borders and so on. So it's not an event. It cannot be an event. And it's something that people, I think I must stress that it is something that would take time as people get more and more comfortable around it, as people see more and more successes. That's what I'll say. Thank you.
Yeah, thank you for your interventions, both of you. I'm really grateful for that. The high points that I take from your comments thus far, that it is clear that it is a process. Daniel was really emphatic on that. Francis has pointed out that it is critical that we set up certain kinds of institutions like the Trade Remedial Agency or Authority to articulate national viewpoints and obviously interact with the private sector that is involved in the day-to-day transactions that will make after come alive, as well as a change of mindset. That's the other thing that he's mentioned, that there needs to be change of mindset. That's the other thing that Francis has mentioned, and that's very important. And may I say that change of mindset has to operate not only in the commercial sphere, but also in at the government level too. We need to recognize that our future is interdependent on what's going on around us. And it's only then that true prosperity can come to the greatest number. So that's the point. Those are the high points for me from the first question. But I think it behoves me to also ask this follow-on question, and maybe I'm asking Daniel, and perhaps Melu can jump in if he feels that there's a need. When you said deadlines like 2035, I believe that's correct, with regards to tariffs, as well as 2035 with regards to services. Isn't that an excuse to cop out? Isn't this something that there should be decisive action, and then the timelines be abridged in order to bring the benefits in much quicker? I would have said it's a shorter period of time would have been better. But guys, what do you think? Please let me know your thoughts.
Okay, so I think Mark, I think 2035 is actually a fairly ambitious target. And the reason why I say that is because if you think about the history of the European Union and how long it took the European Union to develop and to be in a position where they could freely allow for goods and services to transfer across borders. If you think about other regional blocks, even those which are in the African continent, it's been quite a journey in order for you to get there. In a sense, Africa is much better placed because we already have a lot of learnings. So for example, if you look at the East African community, if you look at COMESA, if you look at SADC and the learnings that have been done there, and if you look at how those learnings translate to what we now have in AfCFTA, it therefore means that effectively we shouldn't take as long as other parts of the world have taken, or even as long as Africa itself took when they were initiating regional trade blocks. But the reality of the matter is that the 2035 date, and in terms of progressively achieving, is one that will require a significant concerted effort. If you think about it, with the initial pilot project, just getting the initial consignment of tea from Kenya across all the way to Ghana by road has taken almost 4 or 5 months. And therefore, this period of time is not just from a perspective of what the law requires to provide for. It is the practical steps that will need to be put in place from infrastructure in order for you to transport goods across the African continent, to the breaking apart of borders in order for people to move freely, the immigration laws and the visa applications that need to be dealt with. It's a very complex process, and it is one that when I think about the 2035 period that has been given and the timelines that have been given, I would not call them as an opportunity to cop out. I think it's much more aspirational to some extent in order for the whole of the African continent to be fully engaged through this project. But I don't know what my esteemed panelists will also say on this issue.
Thank you, Daniel. In fact, I couldn't have put it better. I think I noticed Francis smiling when you're saying that we are not doing too badly. And in fact, you're absolutely correct. I would refer perhaps this
recording in progress.
All right. I would just like to refer to, for instance, 2 points. One, that the benefit of having regional bodies across the continent, West Africa, East Africa, Southern Africa, and North Africa, have been evident in the speed with which the AfCFTA has been concluded. I'll use the following example as a reference. There's another big trade bloc that exists in Africa, which involves SADC, COMESA, and the East Africa community called the Tripartite Free Trade Area. That agreement still hasn't come into force. It requires only 13 members to ratify it. We're struggling, we're still sitting at 11. With the AfCFTA, out of the 54 African states, 43 have ratified. We are speaking about a pilot project called the Guided Trade Initiative. So actually the agreement is alive, and its implementation is taking shape. So I do think that firstly, the benefit of the learnings have come through in this agreement. But secondly, what are the implementation challenges such as logistics and so on are really what we have to go through. It's basically a better problem to have. In other words, it means we are working, and as we're working, we are finding out that there is this to fix, there is that to fix, and we are fixing. Thank you.
Thank you. Thank you. The incurable optimists have win the day on this one. Well done. Now, I think I'm going to jump one of the questions and move straight to question 3. One of the key features of AfCFTA is the free or unrestricted movement of goods and services between state parties. This will entail concessions in tariffs and duties. So, Mr. Oyebode, I want to put one of the questions to you. As an organization carrying on business in the jurisdiction of a state party, what has been your experience in AfCFTA, and has the entity which you work with enjoyed the reduction of tariffs at this point in time?
Okay. Now I feel like the person raining on everybody else's parade at this point, because as you said, they were the eternal optimists. Now I'm coming from the private sector, and I can tell you for
reality,
yes, that yes, when it's done, it'll be a beautiful thing to see for Africa, and we shouldn't, remove what we have now from what the primary objective is. But at this point in time, I believe it's still very, very much in its operational infancy stage. And it would still need a lot of time. And by a lot of time, I mean a lot of time for us to get to the objective, which is the free trade between countries. The tariff, at this point, no, it's not existent. And also part of the problem is something Tola mentioned, either Tola or Francis, about how even the custom officials are unaware. They have no knowledge at this point of what AfCFTA is about. So, we would need to start, a lot of the issues AfCFTA is having can be broken down to institutional and non-institutional barriers. And the institutional barriers will be domestic economic policies, governance, the legal and political framework of each country. For the non-institutional, there will be things like infrastructure. We have inadequate port facilities in most of these countries. We can barely, let's use Nigeria as an example. All of us are aware of the time that things at the ports were there for 3 months. They just couldn't cope. So for us to now say we're going to tariffs, we haven't even gotten the rudimentary part yet. We haven't gotten to the point of tariffs coming out and being of use to everybody.
Thank you, Mama. I think your comments are still, it's still necessary to hear them, to have a balanced view of where we are. And I suspect that the things we are hearing in reality will further act as impetus for AfCFTA to, kick on, for the implementers to, take all the necessary steps. But Sheil, I wanted to talk to you next. What are your views with regards to this question, considering that you're working for a Pan-African bank, involved in all over the continent? What has been your bank's experience with these kinds of things and some of the clients you represent, in trade?
Thanks. I do share the same sentiment with Mrs. Oyebode. In engagement with our clients, there's been that difficulty moving goods across African countries. I'll give you an example. There was a client we were talking to in terms of encouraging their export. And he made us realize that it's cheaper to fly the goods to Europe than back to an African country than to move the goods from Nigeria to the African country. He's talking about the cost of transportation, the different levies that would need to be paid across the borders. And it's good we're talking about tariffs here. And she mentioned that it looks like many of the countries or the participating countries are yet to be aware of what AfCFTA really wants to achieve. So it's not just Nigeria. I think it's across the different African countries. And we need to, I mean, I hear 2035. I mean, I don't want to debate on whether it's too long or too short. But if we don't have a strategy to map out what you want to achieve at every stage before hitting that deadline, you might not get to see full implementation by that 2035. So there is a lot of things to be done: infrastructure, enlightenment, getting participating country aware, and really explaining what we want to achieve before we can hit that target. So a lot of clients are complaining, a lot of issues, structural issues that needs to be settled before we can put the cream on it to make sure that there's a uniform tariff or a unified tariff that will enable participating members, I mean, they are the citizens or the traders, to benefit from what AfCFTA wants to achieve.
Thank you so much for that. Again, another dose of reality, but I'm sure we'll balance out ultimately. And the honest truth is that a lot of this stuff is work in progress. And the points you are making and Mrs. Alaya is making you're both making are, as I said before, be impetus to us getting to the promised land, and it's incentive, if you ask me. There's a question I want to throw out, and it's flowing from, you know, the free movement of goods in the light of the intention of AfCFTA. Are there any mechanisms in place to allow free movement of people? So, for example, I'm speaking specifically to things like visa exemptions, so if we're borrowing from, say, the EU, for example, there's a free movement within Europe, and obviously, I imagine it should be one of the things that we should be pursuing. This should be part of the aspiration of AfCFTA, to have that kind of scenario. So, you know, I'd like to throw this open to Melu first, and Francis. What are your views on the visa situation? Is it possible before 2035 we can have a scenario where we have free movement of people within, you know, the AfCFTA region? What are your thoughts?
Oh, thank you very much for the question. I think, in fact, let me take one step back. The AfCFTA program is a program of the African Union. I am aware that there is another protocol on the free movement of goods, which it's also a product of the work of the AU. The ratification and implementation of that protocol is progressing very slowly. So we are on that front moving at a snail's pace, I agree. I think there are many reasons for that. A part of it might just be lack of political will. Where I come from in South Africa, we have an issue around the ill feelings that people have towards foreigners. It's an issue that's developed over the past 3-4 years. And it's created quite a substantial political issue. And you are seeing some positive responses, progressive responses by politicians, also seeing negative responses by politicians on an issue which in South Africa is settled constitutionally. There's no ambiguity about the treatment of foreigners in South Africa under our constitution and our laws. But it's arising as a sentiment that you pick up on the street, which lends itself to manipulation and abuse by politicians. So I do think that the question of political will has a lot to do about it, and the sentiment on the streets of the various countries. I think I would like to leave it there and hear what my other panelists have to say.
Yeah, Francis. Thank you.
Thank you very much. So yes, indeed, there's a protocol, like my colleague said, there's a protocol on free movement of persons. Like he said as well, it's about political will. But what you already we're already seeing is that a lot of countries are having this visa on arrival programs, right? Which is great, but it needs to go beyond that. And some countries are even moving faster. But this is, it's just like the different parts, right? Now the former speaker talked about taking goods to Europe before getting it to Africa. Is a challenge of skill. As you build skill, then and volume, the costs will start to come down, and then the various routes will become attractive. Similarly, if you use other jurisdictions, even the same way you've got passport for seafarers, you also have some kind of programs for even truck drivers moving across borders and so on. I'm not aware that all these things are yet in place. But again, what is happening is that there is a program. AfCFTA is not just about goods and services. It's about economic integration. And some of these problems, as implementation goes on, as we witness successes, as we see where the gaps are, some of these things will then become demand-driven. But you have all these programs, including free movement of persons, but it will take time as the demand grows, and as we get some successes for some of these things to happen, and some countries will take some bits faster than others.
Yeah, thank you. Is it at all possible, follow-on question, is it at all possible that, aside from the fear, foreigners are coming in to take our jobs, is there also the fear of, insecurity? Is that one of the reasons why there seems to be a lack of political will to move forward on this particular aspect of the integration that we're looking at on AfTA?
Yeah, yes, there's that fear, especially for us. That was one of the issues. Nigeria is not yet a signatory to that protocol, and that was one of the reasons that that was given. But maybe by the time, if you just look at it this way, there is that issue, right, on the negative side. But if people are able to move across border, let's assume some of the infrastructures are there or it becomes affordable. People are able to move across borders to for tourism, to go and watch football tournaments, to go to music festivals, and all of a sudden you see value, start creating value in that sector. Then countries will start seeing the other side of it. So yes, you've got a negative, and it builds that fear. Don't forget as well the public opinion. That is a major drag on how fast we can go with this as well. But again, as these things evolve, as people see the benefits, some of these things will change. But it's not going to happen overnight.
Okay. Melu has some intervention to make. Yeah, Melu, go ahead.
Thank you, Mark. I think what Francis said in his earlier input about demand or driving behavior, that's critical. One example I would like to give, for instance, is a recent major strike that we had in South Africa, where our Transnet, which runs our ports and our rail infrastructure, went on strike. And companies needed to get their goods into the country and their goods out of the country. And suddenly the question was how to do it. And fortunately, because we've got a framework under SADC, which integrates that region, we were able to assist them to find an answer through ports in Mozambique on the eastern side, ports in Namibia, Windhoek on the western side, and a bit north in Angola. Something that private sector wouldn't have considered because they had the comfort that things were going normally. But here a situation presented itself where they needed to think creatively, and the solution was actually always there. It's just that there wasn't any need or demand at the time.
Yeah, I mean, sorry to take you up on that point. Is it more of, is it that there's a benefit as opposed to demand in and of itself? In other words, what I'm saying is that the progression to the, adoption of these, what you call it, the protocols, the ultimate benefit is, or what drives it is the benefit. When the sovereign sees that at the end of the day there's a benefit, then that pushes and drags everyone along. That's the way I really read it. Not demand is a byproduct of that particular benefit, if you like.
Absolutely, in fact, you're right. These agreements are by design meant to allow us to get preferential
treatment amongst ourselves,
and that's inherent in that is benefit.
Yeah. Thanks. Let's move to question number 4. This is Daniel and Professor. And Tola will take this question, and then the next one will be Professor Aremus. So, rules of origin are the criteria needed to determine the nationality of a product. They are important because duties and restrictions are in almost all cases dependent on the source of imports. That is to say, if a good is going to be excluded from a tariff, then as of necessity, we should be sure that where it's coming from. And that's what, in summary terms, a certificate of origin is. So Daniel, are you able to share your insights on the rules in practice right
Sure.
now? And do you think that the finished products produced by a state party but with raw material from outside of Africa, would it qualify for trade under, or would it qualify for exclusion from a tariff under AfCFTA?
Sure. So as you say, the rules of origin really determine the economic nationality of a product, and the rules as they currently stand, the rules of origin under AfCFTA were released, I think, in July 2022, so fairly recently, but they largely mirror what you'd expect and what has been issued previously by the regional economic blocs. But the rule usually is as follows. You firstly look at whether the goods were wholly obtained in the country concerned. So when you look at the AfCFTA rules of origin, they give a couple of examples. So for example, they give, if gold is mined out of South Africa from a South African mine, the fact that it has been obtained from the soil of that country makes it wholly obtained in that country. They give another example of, for example, maize that has been grown in Kenya, but the seeds were obtained from Argentina. So they say that in that case, because the maize has been grown in Kenya, it would be considered to be wholly obtained, notwithstanding the fact that the seeds emanated from another country. And to the extent that the goods are found not to be wholly obtained in that country, you then go to the next step, which is a sufficient production or transformation occurred in that country concerned. And that is really a three-pronged test. You look at value addition, how much value addition has been given or been generated in that country. You look at whether sufficient change has occurred in order for you to change the tariff description. So as you all know, in most instances for tariff description, there would be a description and a tariff classification. So if sufficient value addition has occurred for you to move the good from one tariff classification to another, that is another criteria. And then the third one is where you look at specific operations that have been undertaken in order for you to then fall into that category. So these are the sort of things that would need to be considered. And what I also find really fascinating is the fact that each of the regional economic blocs have their own rules of origin. They largely mirror each other, but my sense is that the percentages of value addition, for example, change or differ from country to country. So it goes back to the point that has already been made, that you would find that a lot of the revenue authorities across and customs officials do not necessarily have a full understanding of how this process will work under AfCFTA. So coming to your question, where the goods have been imported, the raw material has been brought in from a different country, it will then be the case that those three steps in terms of sufficient production or transformation having occurred in the country concerned will need to be demonstrated. You need to show that there is sufficient value addition, or for example, where there's been a tariff reclassification, or specific corporations have occurred in order for then that good to have the economic nationality of the country that seeks to say that it originates from there. A very interesting example, for instance, and it raised a few eyebrows, was the company that was involved in the original pilot project for ceramics in Ghana was actually a Chinese company. So it's a Chinese company, set up a plant in Ghana and began manufacturing the ceramics from there. And the obvious question that arose was, should these goods, which effectively are being manufactured by a Chinese company in Ghana, meet the rules of origin tests? And ultimately the outcome was that actually they should, because provided you're able to demonstrate that those factors have been taken care of, either value addition or specific operations, or have undergone some form of transformation, you would then satisfy that regardless of who the owners of the capital or the investment that has been done. So I don't know what Tola, passing on the back to Tola here.
No, I think that you've been very clear. I want to ask Tola another question that flows from it. It's a bit off script, but I'm sure he's more than able to handle it. My question is, why are certificates of origin important to the business world? What does a knowledge of certificates of origin do for people who want to be involved in AfCFTA, businesses? Why is it important to them? So I thought please take a stab at it.
Thanks. Daniel had done all the good work. I was willing to just say, thanks, Daniel, thanks, Francis, but I feel like I've been set up again. So the way to think of certificates of origin, right, is think of it as a shield and also a defense, right? And I say this because if anything, what it does for you is protect you as a legitimate African AfCFTA business person. That's what it does for you. And I think the way to think of it is simple. So and I would like to use real scenarios so that it just looks a lot more real to people. So let's imagine that I am a manufacturer of tires. Yeah, let's use tires, right? I import my rubber from Nigeria, or I get my rubber from Nigeria, I get my rubber from Ghana, and I make tires, and I like to sell it across the region. Excellent business. I'm investing in my continent. I'm spending a lot of money, raised a lot of money, right? Great. I'm going to have to export my tire after I've made it across Nigeria, South Africa, Kenya, Ghana, all those places, right? Now, at the same time, there could be somebody in, I don't know, France, Italy, any other country outside of the AfCFTA who also makes tires, right? This person can make these tires, bring them into any country, maybe Nigeria, Ghana, and then also transfer it across the continent. So we're both making tires. If you went to look at both tires, on the face of it, they both look like tires, right? And don't forget, with these days, you can brand anything on the tire, right? You can write made in Nigeria, you can write anything. The question is, but when you negotiated the AfCFTA mechanism, you wanted to ensure that the only people who enjoyed the benefit of reduced tariff, like Daniel explained, are those who are actually created within AfCFTA member states. The reason is because this benefit is for AfCFTA member states. There should be one that should enjoy the benefits. But when I look at the tires, they both look like tires. One says Daniel tires, the other one says Gumi tires. How do I know who made which tires, right? And then what's also more interesting is I could also write anything on it. I could write made in Nigeria. It's printing, right? How do I know this is actually made in Nigeria? What a certificate of origin does, and don't forget also that when you're negotiating these things, you also decide according to each good. So there are about 2,000 or 3,000 tariff lines. You determine according to each of the tariff lines, what's the level of transformation. Because don't forget that depending on where you are, different things meet different standards to be AfCFTA goods. I'll give you an example. For tire, you might say, for a tire to be an AfCFTA goods, the crushing and molding must have been done in Africa. Finish. For a car, you might not say the same thing because cars are more complicated. You might say things like, you can bring the carcass of the car from any country. As long as it's assembled in Nigeria, it qualifies. For yam, you might say, oh, yam must be planted in Africa. So you create all these different standards of rules of origin across different ones. What the certificate of origin does is basically having a body look at this product you are saying is an AfCFTA product. And they'll basically say, what's the standard for what satisfies AfCFTA goods in this category of industry. And then they'll certify and say, yes, you qualify. So let's say 7 of us go to Nasima. Nasima is the one in charge of rules of certificate of origin in Nigeria. And I go on my tires and I'm like, this is my Ngumi tires. I made it in Nigeria. They'll say, okay, what are the proof? Oh, yes, you actually got the rubber from Nigeria. The rule says for tires to be made AfCFTA product, rubber must be got in Nigeria. Check. You crushed it in Nigeria. Check. You blended it in Nigeria. Check. You molded it in Nigeria. Check. Okay. This is a certificate telling you that this is actually rubber made in Nigeria and it satisfies the requirement for an AfCFTA goods. So they can come with their car and say, this is my car. It's an AfCFTA good. So, okay, let's look through the requirements. What requirement did all the countries agree for motor vehicles? Oh, for motor vehicles, they said that you can bring a carcass from anywhere in the world. Okay, fine. But they said that it must be assembled in Nigeria. Did you assemble it in Nigeria? Ah, no, I assembled it before I brought it in. Oh, this does not qualify. So what the certificate of origin does more than anything is help you know, one, does this good satisfy AF? Does it satisfy the threshold of what it means to be an AfCFTA good? Two is, can I then enjoy the benefits of the AfCFTA as I export? And so that becomes your proof that you export your product. So as you export it across the AfCFTA countries, when it gets there, all they'll ask you is, you are saying I should charge no tariff. Show me your proof that it is actually AfCFTA goods from Nigeria. Oh, here's my certificate of origin, that's all. And that's basically what it does for businesses, which is one of the reasons why 3 things are important. One is ensuring that for each product line, we're negotiating the right rules that apply to you. But second is ensuring that even the administration certificate of origins are as seamless as possible, right? And that's one reason why we notice it's not being issued by government, it's issued by chambers of commerce, so that it's a lot more efficient than if a government was issuing it. And the third big thing that matters is ensuring that member states recognize and can authenticate all the certificates of origins that they come across.
Thanks, Tola, for that contribution. Mrs. Olayode wants to ask a question, but before she asks, something just crossed my mind while you were speaking, and I'd just like to take you up on it real quick. And the point really is, in other words, and I'm trying to sum up what you're saying and tell me if I get it right, you're basically saying that an entrepreneur in Africa, after having looked at the certificate, the certificate of origin in a particular, product or industry, can then identify his value chain, A, B, and then map a course of premised upon which would ultimately, enjoy the reduced tariff that will allow him earn much more, because ultimately all of this is about enhanced prosperity across the continent. Is my depiction, my summary correct?
Yes. So basically, in high level, it's that any business person can look at the negotiated rules of origin for his particular industry and use that to map out his production line so that it benefits from the AfCFTA, because then it can become an AfCFTA good. Yeah.
Thank you. Peradventure, there were any entrepreneurs in the room or online? Well, this is for you. Mrs. Olayode.
Okay, Daniel, this question is for you. You mentioned about the Chinese company, that the rule of origin for the Chinese company. So for me, my understanding is the whole essence of this AfCFTA is to bring prosperity to Africans. What stops expatriates from coming to an African country, setting up a factory like they did, and because it was done in Africa, but we all know they're all expatriates that own the company and they can benefit from it. It's supposed to bring prosperity to us. That's the main aim. Reduce poverty in Africa, raise our economy, and all that, all the good stuff. So why would we allow something like that? I'm just asking.
I can start, and I can see Francis' hand is also raised, so he probably wants to jump in on this one. So the very interesting thing is that, for example, when you look at the North American trade area, the significant amount of investment that went into Mexico actually emanated from the US. And the key question that arose was, why is it that the biggest beneficiaries from a perspective of investing into Mexico for purposes of then exporting back into the US using the free trade area, why is it that the investment and the benefits of putting in the investment was primarily by people from the US? Now, ultimately, it follows that even though there's a free continental trade area, as is the case with AfCFTA, it does not follow automatically that capital is available on the continent. In an ideal sense, it should spur on African investors and it should spur on significant entrepreneurs in Africa to put in capital in order for them then to utilize and benefit from the free trade area. In practical sense, as long as we don't have capital, and in reality, there is nobody in most of these countries who has been prevented from bringing in capital from another part of the world. It therefore means that an entrepreneur from anywhere else in the world can come and take advantage of the free trade area. So it's one of those things that that will be an interesting outcome, where we will foresee in due course individuals who will put in capital for purposes of benefiting from the free trade area, even though they may not necessarily emanate from Africa. But I can see it's a hot topic and many people want to jump in on this one. Francis and Tola and I think also Professor.
Francis?
Yes, thank you very much. I think this is quite interesting, and we're getting to the practical side of it. So AfCFTA is not the sum total of any country's economic program. A key element of what you're looking for is investment. FDI is a key indicator of your competitiveness, isn't it, and your operating environment, right? So you actually want the investments. By the time you companies from outside Africa coming into an African country to establish business so that they can take care of AfCFTA is an endorsement of the AfCFTA program. But it also talks about the ways that AfCFTA will work in practice. So this one, we're talking about an existing company. We see already, let's take the tech companies. We've got American capital investing a lot, for instance, in the Nigerian fintech industry with the view or with the singular objective to be able to expand into other African countries. We see that already happening even in the insurance industry. We saw that in the AGOA program, where we had all of a sudden we saw so many Chinese companies in the apparel in Swaziland and other areas establishing to be able to take advantage. The minimum that it does for the country at the direct level is creation of jobs, right? Indirectly as well, there are the indirect effects on adjacent industries, and of course the induced effects on government taxes. So really, it is something to be encouraged. And under trade in services, the 4 modes of services, one of the modes of service is establishment of subsidiaries in other countries. So the AfCFTA not only allows you to come and establish in Nigeria, for instance, or any other African countries, but also should make establishment of subsidiary companies in other areas possible, so that you can take advantage, you can grow your market share. What we are looking for is creating trade, creating value across Africa. So it may not sound, talking about public opinion and all of that, these are the things that we need to start to understand the benefits, the practical benefits of this, so that we can actually support them. But really, it's about attracting investment and creating jobs in Africa.
Yeah, thanks, Francis. Before you have an intervention? Did you want?
I just wanted to add. If there's no time, then I'm
one sec. We also have Professor RM who wants to make an intervention, but I think before we take his, and we'll have both Milo and Tola who want to chip in also. But before we take his, I just wanted to make the point, especially for our listeners, that I think it's a key takeaway is that AfCFTA is meant to create an environment that would then attract FDI, the foreign direct investment, that will allow for the creation of jobs. And it's in the creation of jobs, acquisition of skills, that you are going to, and upscaling your skills, that we are now going to find the prosperity spread out.
Am I the only one who think they're frozen?
Plant in the United States, and those are examples of this, what Francis was alluding to, how the right kind of environment allows for creation of jobs and the distribution of prosperity. Prof, let's take you, and then we'll take Melo and Tola last, and then we'll move on to the next question. Prof, can you hear me? Prof, can you hear me? I understand we can't get his video, but we had his audio. Is he on? Prof, can you hear us? Okay, let's take Melu and then take Tola. If Prof comes on, then great.
No, thank you very much. You've actually captured it succinctly. The value that you want to create and you want the continent to benefit from isn't limited just to the ownership of the asset. It is, you look at the entire value chain. If you want to produce glass, for instance, and you mine the mineral in your country, and at the end you produce glass that you sell all over the world, you have created jobs. And more importantly, and for me that's the most important part of all of this, is that you want your society to be sufficiently skilled to be able to respond to its own needs. And if you don't have that skill in your society, you then should be able to access it from somewhere, because the impact will be long and will last for generations. And that, for me, is one of the strengths of this idea that the AfCFTA is founded on. Thank you.
Thanks, Melo. Tola, you had an intervention.
Yeah, what I wanted to say was more the legal and the policy implications of it. So, right. So the thing with law is there is corporate legal personality, right? So a company is a separate person from an individual. So the problem is the AfCFTA says, I want Africans to trade more amongst themselves. The issue, however, is that a Chinese company registered in Nigeria is a company, right? And is a person for the sake of the law. And so satisfies that requirement. And so that's the interesting implication of saying, if a Chinese person sets up a business in Nigeria, right, does he then become a person? Yes, he is for all AfCFTA purposes, right? He's a person under the law. But the thing is this, and this is where it gets interesting, and that's why rules of origin are incredibly important. Rules of origin is saying that it's not enough to just shout and say, oh, I'm a Nigerian company. You must satisfy the rules of that product. So, and that's why rules of origin, because it's not enough to just say, I'm a Nigerian, because one way you could have done the rules of origin design, or AfCFTA design would simply say, as long as you're an African, you can trade across the continent. But the question is, because companies can be persons, it becomes easy for people to game those kind of things. And so what you want is you want skin in the game. You want to say for each product, these are the minimum thresholds that each person, each product. So if you say there's kind of manufacturing, making shirts, making plastic bottles, you want to give thresholds. So that the idea is that anybody who meets this threshold is fine, and also conjunctively is an African, has ties to an African, to an AfCFTA company. Because there's almost a conjunctive implication. You're an AfCFTA person, and you're a person in the AfCFTA member state, either a company or an individual, and you meet the rules of origin certification in those countries, in that country. What it means basically is that, so it means even if I'm a Chinese business that I want to, I then have to maybe set up a plant in Nigeria. I have to spend X on manufacturing in Nigeria. And so in the end, what ends up happening is that from a contribution to the economy point of view, and what they call nexus and connection to the local market, there's enough link. And this, by the way, is a very well-tested theory. If you read the rules of, if you read the protocols on even investment, you see a lot of things like that, where you talk of things like the right of a member state to refuse benefits if you don't have enough connection and can show that you've done enough investment in that country. That's a big part of the protocol on investment. If you go and read it, it's actually called the right for a country to refuse to give you benefits if they say that you are a shell company or you don't have enough connection to the member state. And it's a big rule. And that's why those things exist, to ensure that, because you don't want to have a world where, for instance, look at all the Nigerian startups today who have US holding companies. They're African companies, right? But they have US holding companies. And if you draw rules in a way that is too broad, you actually call those people out of being able to access the market. So you want a balance of saying, one, you are an individual, whether a person or a company, within an AfCFTA member state, plus you meet the rules of origin requirements for that specific product, and then you can get the benefits.
Okay, thanks. Thank you. Okay, yeah, you want to intervene?
Yeah, so
Sure.
I just want to add something because I know she asked that question out of concern because of the local content and how it's going to benefit the citizen. Yes, we've spoken about the foreign company, foreign individuals or company coming into the country, establishing a local company in Nigeria, increasing employment. But I think there's also the point around control, right? By the government of that country to ensure that that foreign company actually keeps to the agreement or keeps to the rules. Yes, the certificate of origin would play a major role, but you want to look at things like, we've spoken about employment. Who are they employing? You've created job opportunities. Are you using your own nationals or using the local people in the country? And I think that's where your concern is coming from. So I think what we need to do, and this has to do with the various governments in each country, ensuring that the companies in question are keeping to the terms, and there should be local laws and local rules that will guide that as well. Just
yeah, I get the point. I mean, just to answer the point. So in Nigeria, for example, you have immigration rules, you have no tap, you have these rules tend to ensure that say the immigration rules ensure that you can't bring a foreigner in to do work that a Nigerian can do. What's that thing that they go, yes, the TWPs, expatriate quota, exactly. So with those rules, there's a system to ensure that there's a transfer of head knowledge to the locals, so that we are as well as skilled as those who are bringing in the capital, as well as things like NOTAP that ensure that technology is processed and transferred to local entities. So that pretty much captures all of that. So thanks for the contributions. I'm grateful. Can we move to question 5? I don't know if Prof is on now. Is he on? Is he in? Is he on? He's not on. Oh, wow. Okay, let's move on to question 5. On 7th October 2022, after Secretariat launched the Guided Trade Initiative, the GTI operates with a list of products that have been earmarked to be traded. We've discussed some of them already. These products include ceramics, tiles, batteries, tea, coffee, processed meat products, cornstarch, sugar, pasta, etc. The rules of origin with respect to such critical products like textiles and automobiles, which constitute about 13% of the number of all tariffs, remain to be finalized. So how do you think that the, and my question, I'm addressing my question to Francis and to Sean, if you would take a stab at it, in the alternative, Melu. So how do you think the non-completion of these rules on critical products affect the implementation of AfCFTA? And what are the challenges in attaining the desired outcome? If Prof is on, please, can you come on also? If not, let me take Francis and yeah.
Okay, thank you very much. I'm not sure it's correct to say that the rules of origin have not been completed for most of those products. As far as I know, there are only a few call it product lines that are outstanding, especially the auto, textiles, and so on. But on as far back as a year ago, we had achieved over 80% completion in terms of rules of origin. And it was at that point that the call was made. Why wait to get 100% when you can already start trading with the 80% that you've talked about? And we're talking about 6,000 tariff lines, and you've got 80% of it. That's more than enough for traders to start. So from a rules of origin perspective, in terms of agreeing it at the AfCFTA level, a lot has been done, enough to start the guided trade that we've talked about. And the guided trade, those products were based on the ones that the 8 countries have said, okay, let's start with this. These are the areas that we want to start with. That does not mean that it will not extend as more more countries get on board. Now let's bring it down to let's use our Nigeria case, getting it started, which is what I think the private sector would like to know. So the rules are there. We've got our local laws that enable us to set tariffs. So what is outstanding in Nigeria is to get these agreements at the AfCFTA level gazetted, or all the administrative procedures at the ministry, customs, and where required, the approval of the president where required to take place, so that the customs can then issue the necessary guidelines and say trade can start, and these are the processes, just like you have for your normal HS code, and you have for other preferential trade programs. So it has started. For those that are outstanding, yes, it's outstanding, but that's just about less than 15% of the entire tariff lines.
Maybe the question is, why don't we move out of the simulation phase, to borrow Tola's word, and move away from just the 8 countries within the GTI, and now that we've done a bit of a dry run, more countries can get their hands dirty, if you like.
Okay, so let's be clear. Nobody is it is not fixed that it must be only these 8 countries. So I'm aware that okay, in my former position, we had a conversation before I left late last year to say, right, okay, these are the steps that you must take. The moment a country completes those administrative steps and say go ahead, boom, you join. That's it.
What's the traction been like?
Sorry?
What's the traction been like? Have there been any, what's the traction like? Have other countries, joined in, or are we still exactly with the same 8?
No, at the moment, to the best of my knowledge, you've got that 8, but various countries are at various levels of concluding what needs to happen locally. They need to complete their local bureaucratic or administrative processes. And once that is done and the approval is given, boom, they will enter. That's it.
Okay, Melu has a contribution. So let's take his contribution. We're beginning to be pressed for time. So I'll take 2 more questions and then we'll open the floor.
And Prof is back as well, so.
Okay, so Prof, are you on? If you are on, let's hear your views.
We have to some of the things I've been hearing since.
Yes.
Number one sentence before I look at the one that is very critical to me, which I had to do. Number 1, that AfCFTA is a process, not an event. It's a process because this process started since OAUs were formed in 1963, and then we have a Lagos Plan of Action, we have the African Economic Community Treaty, and then that actually explained the 4 processes, the 4 phases of economic integration. And then after that, we now started African Continental Free Trade Area, which is the beginning of the economic integration. Because after this one, we are going to come to the stage where ECOWAS is now, which is customs union. That is to say that the import duty across all African countries is going to be the same for products coming from the third country. And after that one, we are going to move to common market. And finally, we go to what is called economic union. So it is a process, it's not an event. Then secondly, a lot of impediments have been mentioned, of which Francis talked a lot, other people talk a lot. But what I wanted to say is to react to the fact that in the development of Pan-African Investment Code, we recognize the importance of foreign investors. And that is why when you see the protocol that was adopted just about a month ago, the protocol on investment, the protocol on competition protocol, and then the protocol on intellectual property rights, you discover that definitions of investment are quite clear. Foreign investors can come in, and according to my junior brother Tola, it's perfectly correct that once a company satisfies a corporate citizenship of a country, such company is qualified to be a member and participate. But again, that is an area where the monitoring aspect of investment in Africa, we need to check quite well, because the experience we have under the Berkeley report is that over 65 to 70% of the 70 billion that leave Africa every year are corporate wrong transaction, illicit financial flow. And you know, this one can actually be perpetrated by transnational corporations. So which means we need to welcome investors. We need them to be corporate citizens, but at the same time, because they are coming from another country, and because of other things like the transfer pricing, another thing they be engaging, we need to be a little bit more careful and making sure that they actually affect us positively. So with other things like the payment to private sector, we really identify all those ones in the development of the national strategy in Nigeria. And I believe other African countries are doing that. Yes, there is going to be some impediment. And individual countries, particularly the government, must actually put in place an enabling environment that welcome investment, that actually ensure that people can do their business with little or no problem with respect to infrastructural delay or problems. The other things that are very important are things like transportation. African Continental Free Trade Area, without intermodal and modal transportation, will never work. So the experience we have in ECOWAS with respect to with ETLS shows that yes, we have ETLS, but when you look at our border from Nigeria to other West African coasts, there's still so much delay. And when you are talking about perishable goods, which somebody mentioned when giving an example of Ghana, this kind of a thing can be very, very disappointing. So there must be a way of linking the transportation system, not only in terms of one giving the other, but in terms of contract agreement. And that's where lawyers will have to come in to be able to ensure that the intermodal and the multimodal agreement that are put in place to enhance the movement of goods across the borders of Africa. So there's still a lot to be done. A lot to be done on the issue of what was discussed in under the first panel with respect to this settlement. I cannot but agree with everything that is said there. Then how do we enhance our competitiveness of our farms? Let me say this one, that the opportunity created by African Continental Free Trade Area will guarantee vertical integration both forward and backward. That is to say, companies in Nigeria, companies in South Africa can have their branches because of right of establishment and free movement, which is both in the framework agreement and also stand in the standalone protocol. So they are going to have the opportunity to vertically integrate and source their materials from any part of Africa and use them as input, intermediate input, finished goods that go into other production process elsewhere. So it's a very, very wonderful, unique opportunity that we create multiplicity of supply chains. But then back to the issue of trade in services. That is an area in which a lot still have to be done in terms of knowledge, in terms of mode, and Francis said, in terms of mutual recognition agreement. By now, I expect that all the 5 priority sectors should actually be engaging in things like mutual recognition agreement, that professionals actually agree on what qualifies a service to cross-border. And it is when they actually agree on this one that they can actually submit to their government so that their government will input into national strategy And so that when those professionals are coming, or when they want to actually participate in mode 1, mode 2, mode 3, mode 4, then they will have an easy passage. So this is what I can just say for now. I'll be able to participate in other questions as they come. Thank you.
We give Prof a round of applause. He's a master of his subject. It's not seriously now. Thank you so much, Prof. We've almost run out of time, so I'm going to skip. I'm going to go to the last question, and it's one of my favorite questions. And it's addressed to Daniel, question 9. And it deals with AfCFTA and IPR rights. Now, Daniel and Daniel, Tola, and Melu, any of you who want to jump in can jump in. Considering how central the promotion and protection of IPR is to achieving AfCFTA objectives, what impact will the absence of or the non-ratification of the protocol on IPR have on trade under AfCFTA provisions? And how far can trade under AfCFTA go without a protocol or without the ratification of the protocol on IPR? Daniel.
So thank you, Mark. I think to begin with, the IPR protocol has recently been approved. I think it still remains a draft legal instrument. I don't think the contents of the protocol have yet been made public. However, as far as I understand it, it is meant to effectively promote IP rules and standards, and effectively to promote the growth of business and economic integration, primarily by doing a number of things. The first one is to create an ability for enforcement of IP policies, combating what's called trade in counterfeit and pirated goods across Africa. This is a very big problem, particularly on my side of the continent, where we have a lot of counterfeited and pirated goods. The second one is to try and create a sort of unified approach with respect to the current legal landscape, where we currently have a number of overlapping regimes which deal with intellectual property rights. And I think the complexity would even be greater when you think about Francophone West Africa and Anglophone Africa, and trying to gel that plethora of legal regimes in order for them to have a systematic approach when it comes to dealing with intellectual property. And I think the third one is really from an African context, trying to think about, can we come up with African solutions vis-a-vis what we consider international intellectual property regulations. And these sort of African solutions would really be thinking about geographical indicators. There's an idea about traditional knowledge, an idea about traditional cultural expressions, and how all these are gelled together in terms of coming up together to put together a regime on intellectual property rights that gives African solutions for African problems. So a key issue, for example, from an African perspective, is that there were traditional medicines that could have been monetized, that can be monetized. But those traditional medicines, if you try and put that within an international intellectual property regime, the ability of then giving intellectual property rights becomes quite problematic, because it is a foreign concept, not necessarily one that embraces or approaches traditional ways of dealing with these sort of things. So our understanding, and as I said earlier, I haven't seen it yet. I don't believe that the contents of the protocol have been made public, but I want to hope that these sort of issues would have been captured there in order to give us an entirely different approach of dealing with intellectual property. I think one other point is that for a long time, there has been an argument that we should be doing more as the African continent to actively push for technology transfer. This was tried through TRIPS. This was tried through various UN parameters. It was never really achieved in a proper sense as to how technology transfer and transfer of knowledge could actually be transferred to African businesses and African people on the continent. And I do think that this gives us a real possibility, assuming that Africa sticks to its guns, and also assuming that we move from purely the letter of the law to the spirit of effecting it across the African continent, that we will be able to make a real change on the African continent should this see life. Handing over to my esteemed panelists. Thank you.
Hello, Tola.
Yeah, the way I think of the intellectual property provision is that, so I think that you need to think about all the overlaps that's happening, right? One is that Africa's 54 member states, and all of them have obligations under the WTO TRIPS agreement, right? Then a number of them also have obligations under the regional type IP protection agreement. There's OADA, there's ARIPO, there's OAPI, there's a bunch of those things that already exist, right? And so by trying to design this regime, you're trying to navigate all those constricting policy spaces that exist and trying to almost create a web that connects all of that. So it's a bit of a complicated wire trap to trying to navigate. The thing to note is that African member states are taking a lot of varying positions on intellectual property. At the WTO level, it's more, I don't want to touch intellectual property until you touch goods and services. And so this is finally a time when they're having to face these issues by themselves and iron out their own rules entirely by themselves. Now, what the protocol looks like from all the drafts that I've seen is more a overarching type structure that allows member states to start to accept the different agreements that they belong to, but also trying to make nuance for things that might be peculiarly African. So for instance, things like traditional knowledge and a lot of those kind of things, right? Trademarks and a lot of those kind of things. But at the same time, allowing them to have a built-in agenda where they can start negotiating for the things that are actually also ahead of them. I know that a lot of the tech community made a lot of inputs into the IPR negotiations, but I don't think that the delay in itself affects the band of what's possible. And the reason is because, if anything, what it does is move towards, in fact, it's one of those protocols that we spent, they focusing more on harmonization than standardization. And the thing is because all member states already have a lot of obligations under a lot of other treaties, right? An average African country has 3 obligations relating to IP. They have the WIPO obligation, they have the WTO TRIPS obligation, they have the OAPI or type obligation. Some of them have obligations under international treaties that they've, like I know Kenya has under their treaty with the US-Kenya FTA. So basically, if anything, you're basically trying to negotiate a regime of harmonization, and that says 3 big things. One is you cannot give better preferences on IP rights to other non-AfCFTA members than to AfCFTA members. 2 is that you cannot discriminate against AfCFTA members on IP rights. And thirdly, you protect the rights of other AfCFTA members in your locality. That's basically what it does more than anything. So it's basically a protocol that does harmonization of that landscape that exists more than actually trying to dictate a new regime.
Thanks, Melu.
I think I'll be wasting anybody's time. I think the 2 speakers have covered it more than adequately. Thank you.
Thank you so much. So the critical point is that IP rights will be protected. What's going on is a harmonization. I actually saw the Nigerian draft and I helped contribute towards it, though I was not on the negotiating team, but I did contribute at that level. And I agree totally that the idea is about harmonization and then the uniquely African perspectives like traditional knowledge. And I think in some cases, geographical indications were also, brought to the fore in the position Nigeria was taking. And I think they were looking to create a balance between innovation and public use in certain instances. But anyway, I'm greatly, I've been greatly blessed by this wonderful, esteemed and erudite panel that have given us the benefit of their wisdom. And Prof, thank you so much. Tola, fantastic job. Daniel, kudos to you. Melu, up you, as we say in Nigeria. Sheon, more grease to your elbows. Madam, I'm grateful. Thank you so much for having all of you. How could I have forgotten Francis? Francis, I'll come and chop up Morocco when I come to England. But thank you so much, all of you. I really can't say thank you enough. Thank you, everybody. God bless you. What we'll do, let's give our esteemed panelists a round of applause. We'll open the floor now to questions, and I'm hoping that our founder, Binga Oyebode, will be on the line, will be here in the room to also give a vote of thanks. But in the meantime, let's take questions online and from the room. What do we have?
Okay, so we have one question online for Tola, but it was for the first session. I was hoping.
Fire the question. Let's take it.
Okay, so this is from Dr. Sam Ibrahim, and it says, "Hi Tola, good job. My question is that climate change regulators in the EU is beginning to look at using tariff as a tool to force climate change action. The EU has come up with a carbon border adjustment scheme, which will tax imports from countries that do not have carbon tax or have inadequate carbon tax regime. Some other countries have raised concerns that it is a protectionist measure under the cover of climate action. What are your thoughts around this? And do you think that the AfCFTA should also begin to consider a similar regime for imports into the AfCFTA territory?"
Tola?
You know, the beautiful thing with panels is that an opinion that you generally charge $100,000 for, people like to get it
for free. You get to give it for free.
But yeah, so the way to think of it is that, so this is not even an AfCFTA conversation, it's more a WTO conversation, and there's actual possibilities that there's going to be 2, 3, 4 cases at the WTO on this particular issue. I'm aware that China is trying to make a case against this. I'm aware that 1 or 2 Latin American countries, I think Brazil is trying to make a case against this. I know also that the African group is potentially thinking of bringing a case against this. And the reason is that, so these things fall under what they call NTBs, non-tariff barriers, where you don't use tariff as a way to keep somebody out, but you use standards, right? NTBs and CBTs, right? More than NTBs and MBTs, yeah, more than anything. Now, what the EU has done is basically say, see, if you don't satisfy this carbon footprint thing, we wouldn't bring into the country. Now, there are 4 big arguments that's going to happen, and we try to see how WTO would balance it. Under international trade law, you have the right to make rules on the basis of public policy. And most times, WTO tribunals, panels, international trade tribunals allow you that leeway when you talk of public policy. So the EU is arguing that it's a public policy push for climate, for the safety of the environment, right? So it's a strong argument in that sense. The problem, however, is that in a sense, it can be argued as a non-tariff barrier, right, to member states. And especially when you think of the fact of capacity of member states for developing member states to meet up with that. So it can look like it as a discriminatory measure. My opinion is that, my opinion on this has wavered, if I'm being honest. Times when I think that those arguments make sense, but the problem also is that the application is not quite clear, right? The question is, how do you determine the thresholds, right? And also when you look at the background of things like carbon trading, carbon removal, and all those arguments in the past, the debate is, to what level can you say that this is a purely climate-driven action and not just an action to keep other markets out? That's one. But the second bigger argument, which is where it gets even more complicated, is the application. Because there's no standard for applying this, what basically happens, unlike rules of origin where there's a system, what happens is that the EU and its member states are basically interpreting these by themselves. So the question is, if I bring something from Ghana, how do you determine that I have used more than 10,000 carbon credits to bring this good in? Like, what's the basis of making that decision? And all of that becomes a lot more complicated when you think of the interpretation, the application. So I think in the end, it's going to go to the WTO panel. I suspect that the position WTO panel takes depends on how many member states swing. I think that the US will be very anti this provision. And the reason is that the US is not very maximalist on putting climate change provisions into trade. In fact, it's one of the issues that has led to the WTO problems, right? So I suspect that in the end, I suspect that 2 things will happen. I suspect that WTO, the EU would argue it's a public policy move, and member states will argue against it. And in the end, there'll be a middle negotiated position. I suspect that this will not be decided by litigation. I think that member states will negotiate a middle ground. It will be similar to what the EU did the last time, where they said, you know what, these are the rules we will do. We'll vary it in this way, and we'll pay capacity building to member states, to other member states to allow them catch up. I suppose that's where it's going to end. So I think it's going to be a negotiation position more than something resolved by the panel. But I do agree it's a very complicated, and I can't make decisions, I can't make an informed argument on it because there is not enough WTO. When you look at the Ecuador case, for instance, EU-US gambling, there's not enough there's not enough precedent to make a call on how the panel might rule on this kind of situations.
Thank you, Tola, for your insights again. We're grateful. Next question. Next question. Do we have any further online questions?
Yes, we have more
Okay.
questions online, but we'll just take one from the physical audience.
Okay.
Thank you.
There's someone on this side.
Ayokunle Adetula. I'm an IP practitioner, and I'd like to have your view. There's a Pan-African IP organization that is having sort of a strong backing from the African Union. But like you mentioned, there's the ARIPO that is on the side, and DOAPI on the other side. The interesting thing is that, at least as at today, the three biggest economies in Africa are not in any of these, at least not in ARIPO and in OAPI. And the impression on the around members is that they've not been able to particularly situate where or what benefits would actually come to them. Now, in your negotiations and all that, how do you think this would actually play for these big economies? Would you per se say things should collapse into PIPO? Would you per se say individuals or these blocks should retain their standing? Specifically given the fact that a ARIPO, for example, have started this process, the Swapukond protocol that talks about protection for traditional folklore and all those things, that is actually getting a pushback from major countries. Thank you.
Daniel, Tola.
Daniel, do you want to go? Should I go first?
Go first, Tola.
All right. So if historical context is anything to go by, I suspect that the powerful or the biggest economies would keep their IP regimes independent. The thing is, IP is a very powerful tool by countries to use to negotiate. But the thing also is that from a point of view, IP also is very territorial and geographical. So you see what India has done at the WTO, for instance, using IP. Now, for context, don't forget that there's the WIPO Madrid regime that allows you actually just go to register in one country and use WIPO, the Madrid regime, to register in all the other countries and get all the protection. But most still don't use it as much as just going to register in the US, the UK, the EU, and then as many. And the reason is simple. There are two big problems with all that. The first problem is the problem of the root of title. Root of title means that if you rely on the WIPO regime or even the WIPO regime, if your root of title is weak in one country, it's weak in every other country. That's a big risk for a big multinational. So if I'm in Google, I don't want a case where if I'm ever challenged in one country, it means all my extension protection of IP from Madrid point of view is weak. That's a big concern for big countries. The second thing is that big economies like the US, the UK, and even within Africa, Nigeria, Kenya, Nigeria, South Africa, would want to be able to be in charge of their own IP regimes. So my suspicion is that I think that there will be a constant evolution, and the OAPI will keep expanding, ARIPOs will exist, OADAs will exist, all that. But I suspect that from a long-term point of view, most of these big economies will maintain their own regimes independently. And what will happen is that, which is what we usually advise most states, right? You get your protection specifically in each of the countries. So you would see most times, most big companies will get an IP registration in the US, the UK, the EU, Nigeria, Ghana, South Africa, Kenya, and then maybe they'll get OAPI and ARIPO to buffer up for the remaining 17 countries. And that's kind of how people will keep doing it. And it's not because and the thing is, there's mutual recognition, right? And the question you also ask yourself is, if I register in Nigeria, technically, or the US, I should get recognition and protection in all the other member states. Why do people still go to all these countries? Because by the time you go to the local court and in Nigeria and say, oh, I have a protection in the US, they'll tell you, show me under Nigerian regime any proof that you have this kind of protection. So because of that, and because IP is such a powerful thing in the evolving economy, I suspect that what will keep happening is people will keep doing those multiple registrations, in all the big economies, and the big economies will keep maintaining some kind of IP protection within their own territory. That's at least my prediction. Yeah.
If I can just add one more dimension, this is more from a tax perspective, because what we're now seeing is that through the OECD, there's a very, very strong push for the development of intellectual property rights, where the actual sort of work that is going into the development, the day-to-day development of that intellectual property rights is where the IP should be recognized, regardless of who is the licensed IP holder. A good example, and I can say it because it's a public domain, is that for some years, most of you may be aware of M-Pesa. M-Pesa is a payment platform that is very large in Kenya, and originally it was owned by Vodafone in the UK, but a lot of day-to-day development was occurring in Kenya. So there was a strong push a few years ago through the revenue authorities to argue that, notwithstanding the fact that the ownership of the intellectual property is owned and registered in the UK, in actual sense, the fact that all the innovation is happening in Africa means that it should move down to Africa. So what I suspect will happen with this intellectual property protocol, and I like looking at the landscape, the landscape as being one that will continue evolving over the next 10, 15, 20, 30 years. It is just a beginning of an argument that will be made by most African countries that if in fact a lot of the innovation is happening in Africa, notwithstanding where you may have registered the intellectual property right, the actual benefit that emanates from the exploitation of that IPR should actually be in Africa. And I think this is a good sort of beginning. I think it requires people to put it in practice, not just have a legal document that says it, but is not effected in real sense. I expect that over the next 10, 15, 20 years, more and more countries will be saying that if the real innovation, the financial platforms, the apps are being developed in Africa, a mere registration of that intellectual property right in Europe or elsewhere should not give you the economic privileges that come with the asset. And this is really part of the broader conversation, which seems to be part of what is being thought through this new protocol or proposed protocol.
Yeah, I would like to just chip in briefly. I've been doing some work, for an IP bench book for African judges. What I've seen in that process, and these were largely not largely were ARIPO countries. What you find out is that there's a tremendous amount of commonality, in terms of the broad rules and the IP rights that are protected. Therefore, my own prognosis or prediction would be that while there'll be a harmonization of intellectual property rights through the protocol across the continent, what you'll still find is individual registrations within individual countries, because ultimately, if you want to protect intellectual property within a particular jurisdiction, then you have to go to those courts. Going to those courts must be undergirded by a registration within that country. So that's the way I see the territoriality will still remain, but the IP rights will be similar. So if you have an African product that's been generated in Malawi, and it's going across the continent, then as of necessity, you would register in the different places you go to. The OAPI, I think, have a better arrangement where when you register in one, it covers the entire area, and that will continue to remain for French West Africa. But everywhere else, it will be territorial. So that's my two pence on that question. Any further questions so that we can round up? Thank you for your patience. Any further questions? Yeah, that's all. Do we have any other questions in the room? Okay, two, and then that's it. Two. So we'll take this one and two more, and that's it. We're running out of time.
So the comment is, the AfCFTA should draw inspiration from the dispute resolution mechanism of the WHADA. This WTO copy and paste model cannot work in Africa and does not encourage private investments. And then the question we have is from Regina Oumere. She says, is the current IP regime under the AfCFTA collaborative? Does it incorporate the regional IP regimes such as the ARIPO and OAPI, etc.? Or is it set to operate independent of these regional IP regimes?
So I'll, the first question I'll leave to, I'll hand to Melo and Tola. But the second question, I think I'll take myself. So the question was whether it's collaborational, is it?
Is whether the current IP regime under the AfCFTA is collaborative, whether it incorporates the regional IP regimes such as ARIPO and OAPI, etc., whether it's set to operate independent of these regional IP regimes.
The protocol, as I saw it in draft, when we considered it in Nigeria, is simply looking to harmonize. That's what it's looking to do. So in other words, these are the IP rights that we want the courts to, within the region, to protect. These are the IP rights we recognize, and so on and so forth. So to that extent, it's not tampering with the regional arrangements like ARIPO and ORP. So I see it as a harmonization, but the enforcement will remain territorial. Guys, over to you. Next question, Dave.
Thanks. On the dispute resolution mechanism, my view is not to take what I would term a chauvinistic approach to the fact that there is a mechanism that is already in place, which has a proven track record of working, and rejecting it simply because we are trying to generate something new in Africa. I think the trick is to take what works from it and, to the extent necessary, adapt or modify it. There is an opportunity to review and look at the agreement over time. If what we are adopting proves to be unworkable or to be ill-suited, then we will modify it. But personally, I'm hesitant to say simply because it's practiced by the WTO, it will not be good enough for us.
Tola.
I agree. So you don't just change a winning team just because you want to change a winning team. Anyone that plays football would like to say that. So the way to think of it is this: you're trying to design a dispute settlement mechanism for 54 countries, 41 currencies, 7 languages. You have a WTO regime that has worked for 190 something member states. It kind of makes sense that you take a leaning to that in trying to build your own regime. That's one. And one of the things they've done with the DSB was, what were the problems of the dispute settlement system of the WTO? And I think I talked about earlier, one of them around the whole appellate body vetoes of powerful countries. They try to resolve some of those problems within how they thought of their own mechanism to resolve that. The third thing to note that I think is incredibly important to note about how the DSB works, and that's a big advantage of the DSB, is that it also allows member states to try out a number of other things. There's a fork in the road. You can pick arbitration if you prefer that. There's a fork in the road and all that kind of things that exist. But like the other thing to say is, it was not just a case of copying and pasting. It was a case of saying, see, this system has worked. If this system has worked for this number of member countries, it kind of makes sense to not just be experimenting again with countries. And also don't forget that we have a 5-year review process. You can review from time to time. But the idea is that if this thing has worked, then let's actually just take it, improve on the snacks of it, and then make it work for the African continent. And that's kind of what happens. And if you look at it, OHADA, which is what you're proposing, hasn't been as tested as the WTO system. Right? The WTO system has been tested a number of times and has worked. And so the idea is that if this, and when you think of it, the most effective international trade system, or the most effective international organization in a sense, has been the WTO system. It's more most effective. And the reason principally has been that dispute settlement mechanism. And so the idea is that you want to take that. And I think couple that with the fact that states also have the power for a trade remedies mechanism, which by the way is one thing that has evolved a lot. So there's the fact that the states can use anti-dumping measures, can use countervailing measures, can use measures against safeguard measures in their country. When you combine the trade remedies mechanism with the DSB, he actually gives member states, and then with the private sector litigation mechanisms that exist, he actually gives a very robust set of systems for resolving disputes between the African continent for the AfCFTA.
Yeah, thanks, Tola. Let's take Temitai Ojo. He has a question. He's in the room. Can we have a mic there? And then there's one more person on the other side.
Good afternoon, everyone. It's more like a comment. I know we've been speaking a lot, and I apologize I came in late, but I want to emphasize on the area of payments. everybody I've been talking about after the opportunities to move goods around. How do we pay? Which is one of the key elements.
So, sorry, it was because of time. Sean here will give you a treatise on it. So do you want him to tell you what his bank is working on? I know there's something they do, and EcoBank as well, but
I'm aware of some of those issues. I know what PAPS is doing and a lot of stuff around that. I just wanted to
point it out.
Yes, that's
okay.
fine. Then.
But I mean, do you want to just say a word or two?
That's fine.
So, well, since you are aware about PAPS, PAPS is also embedded in AfCFTA, and it's something that they're taking seriously. It's very key, and really is a key point because at the end of the day, you need to pay for the goods. I know the initiative has started, especially with West African countries. The first outbound transaction, supposed to be, it was a penny test, took place last October. And coincidentally, Stanbic IBC was one of the first bank. And it was a transaction between Nigeria and Ghana. That's a GCB bank in Ghana. And also the inbound transaction also took place, the first one took place this year, between the same two banks, first week of this month, actually. So we're beginning to see progress, but I think where you're coming from is that there should be more drive, as in we need to cover a lot. The central banks of the different countries need to also do more in terms of fueling the entire process. We have seen quite a number of clients that want to do trade, actually paying for their trade between these two countries. And for the benefit of some of us who might not know, the purpose of PAPS is, I'm in Nigeria, I have coffee in Ghana, I'm exporting to Ghana, right? And coffee, I'm not going to be billing coffee in USD, right? Or even if the invoice is billed in USD, the idea behind PAPS is that when coffee takes delivery of the goods, it's going to provide CDs to the central bank or to the PAPS, through the PAPS system, and I'm going to be receiving Naira. So the invoice can be quoted in dollars, but he's going to make payment in his own local currency, and I'm going to receive payment in my own local currency. And that's the idea behind PAPS, so as to facilitate. I mean, we have a lot of headache with regards to foreign exchange now, but then that simply takes care of that headache and makes inter-country within Africa trade to be, the payment becomes simpler. But I think there's still a lot of work that needs to be done between the central banks of the different countries.
Thank you so much.
And also, sorry to point out, also a lot of countries need to come on board. I know a lot of countries are still trying to put their documentations in place and the structures within the countries to ensure the smooth flow of this.
Thank you so much, Sean. There's one more question in the room and then we'll close.
There's one more question, sorry, and then Prof has his hand up. So we'll just take the question and take Prof's comment.
Okay. Chidi.
Good afternoon, everyone. My name is Chidi Opar from the Dispute Resolution and Tax team. So I note that the AfCFTA recognizes the elimination of both tariff and non-tariff barriers in goods. I mean, I just want to ask that from experiences, what are these non-tariff barriers in intra-African goods? And then considering the peculiarities of African countries, the conversations towards non-tariff barriers, are they objective or are they most likely going to be subjective, taking into account these differences and peculiarities?
Do you want to go?
Thank you for the question. Typically, a tariff barrier is a quantifiable measure or levy that is applied to an item as it enters your country. So if it's based on the value of your good, it will be 10% of the value of your good. If it's a quantitative measure, to tell you you're allowed to import so much. So it's quantitative. And a non-tariff barrier, it's something which is, let's take a regulatory standard. You're importing cement into Nigeria. In Nigeria, cement has to meet standard A, B, and C in terms of its composition. You take a sample at the border, you test it, and the cement doesn't meet that qualification. It's not allowed into the country. But there are other less, obvious measures which work against the free flow of goods at borders. And the idea is that, and those type of measures, unfortunately about them, that they're not transparent. They are almost a black box. You are almost entirely in the hands of the customs official when the goods reach the border. So the idea about the removal, particularly of non-tariff barriers, is to clear the box and make sure that the system is predictable and transparent. When I export to Nigeria, I know that I need to meet category A, B, and C of requirements. That's it. I can do that repeatedly. I hope that helps.
Prof, I hear you have, Prof, you have your hand up, please. Wanted to contribute. Yes, we can hear you
Thank
now.
you. Yes. I want to say some few things with respect to payment system. Well, the idea of payment system, we started in 2010 in the ECOWAS Commission. And then when it came up, in fact, AfCFTA liaised with WAMI. WAMI is a subset of ECOWAS. That is the Anglophone part of ECOWAS. So the payment system, just as the banker actually said, that is how it works. The debiting and payment is going to be done in domestic currency of member states. But let me say this, that it's not only towards trade that the payment system will work. It will work via investment for capital to move. The capital market integration will enjoy the payment system. I want to invest in the Ghana Stock Exchange. My account can be debited in Naira and they will credit it in CD in the Ghana Stock Exchange or in the BRVM in Anglophone or in shilling in Kenya. So this one will allow capital to move from different countries, not only targeting trading in goods at all. So I think what is left, according to what that banker said, is that a lot still needs to be done by our central bank. Well, in terms of the legal regime, in terms of harmonization of policy, monetary policy, and more importantly, in terms of all the 11 subsectors of financial system under the service sector. Because under the financial services sector, I've not seen much work done in that area. In terms of each of these subsectors, what have to be done in terms of the mutual recognition, that is acceptance of work and cross-border, and which mode, is it mode 1 of a particular subsector, is it mode 2, is it mode 3, is it mode 4? So there is a lot of work to be done by Central Bank of Nigeria, by Central Bank of Egypt, and the main central bank that are actually trying to move this wonderful initiative. And just about a week and a half ago, a month and a half ago, I think the team of AfCFTA came to ECOWAS to talk to the president of ECOWAS Commission so that they can partner. I think that movement has to go around to the entire African continent so that all the payment system can actually be harmonized in terms of their legal regime so that the various mutual recognition that will allow money to flow across border, including payment of capital for stock buying, will be able to be possible. Thank you, sir. Thank you.
Thank you so much, Professor. I'm grateful. I think we've done marvelously thus far, and I'm so grateful for your patience. Thank you so much. Can we give our speakers and give yourselves a round of applause? I'll hand over back to the MC to take us out. We will have a vote of thanks from my colleague, Aluko Oyebode, speaking on behalf of our founder. He had come in before, but we're still, please, Aluko, come up and speak. Give a vote of thanks so we can dismiss.
Thank you, Mark. So I'm trying to figure out where to stand. I don't want to back the panel, and given that I think the biggest thanks goes to our panelists for what has been an extremely exciting session, for both for the first panel and the second panel. honestly, I think I speak for everybody in the room when I say that we've learned so much today. I have taken copious amount of notes. I've also thought in my head how we'll bring quite a few of you back in some shape or form or the other, because I think this is an interesting area of significant growth for all of us as individuals in terms of understanding and knowledge, and also for our countries, and certainly for Africa. I think it's a time of where Africa is on the cusp, really, of coming into its own, and this is a great enabler for that. And I think we should all take an interest to learn and take an interest to continue to develop in this area. So I want to thank the panel. Prof, thank you so much. It's I think the array of books behind you speaks volumes, and we know that they are read. You know, some of us just have books for webinars. Yeah. They're constantly and lovingly read and, you know, and marked up and everything. And we really are grateful for in spite of what Nigeria does to our lecturers, but we really are extremely grateful for people like you, and we hope to have future opportunities in the firm. And I think I speak for everybody, you know, in the room that we're really quite grateful for your contribution. And we apologize for the hitches we had in terms of the connection from time to time. Daniel, thank you so much. We've learned a lot from you as well. Louisa, Tola, of course, who is the guru who is advocating and really, you know, in terms of driving this force, you know, in terms of the roles that you play as well. Thank you so much in terms of, you know, jumping in at so many different, on so many various topics, subtopics within the discourse today. We're really quite grateful. My blue sister, I must mention Queen's College. Thank you so much, Sheye, for being here and giving us, you know, the practical perspective from business people who are the ones that will essentially have to live, eat and breathe, and obviously, hopefully benefit and grow from AfCFTA. Thank you also to Francis as well for your contributions, which were really quite helpful for me, and I took significant notes in that area. Sheung, thank you so much. I think your perspectives as well from in-house and also from the payment side, from a company that I think also has international participation as well, were really quite helpful. Thank you, Melu, for coming to Nigeria and being part of the panel physically, and also for you know, sharing your own insight. And I think maybe you'll go away with some intellectual property from us on how to manage power, because I think, yeah, South Africa, so we can share that with you as part of our initial contribution on AfCFTA. So without taking, I don't like people saying that, so I was about to say it. So, but anyway, thank you so much to everybody, to everybody online. So we can't see you. I know there's a lot of people online who have joined this session, and we hope you've learned a lot, and we look forward to continue to engage, you know, as us as a firm, and also to our partner firms, Weber Wenzel and to Anjawala Kana as well. We thank you very much for joining hands with us to be able to have this webinar on AfCFTA, which I hope is the first of many, many, many more to come, because we've recognized that there's a lot of opportunities. Implementation needs to be significantly finessed. There's awareness that needs to be created, and there's expertise that needs to be developed. So for the lawyers that are scared of AI taking your jobs, and for other lawyers from Africa coming as well to edge in on your pie, the point is you need to skill up, learn. This is a complex area, and that's where you can add value in terms of what you can do. So I think all of us should take an interest, and again, just to be extremely excited. And the only thing I would say I was thinking about as well, I used to round up, was that about time as well, about how time evolves, and that this is a living and breathing area where we are today, different countries are in different spots, and where we evolve to will be extremely different as the years go by. And I think England and Brexit and the EU is a good example of the fact that it's not something that's cast in stone. And the policies we make today will inure to our benefit today, but we also need to always be aware and also be flexible as to the changes of how we grow. So while we'll welcome certain skills, who knows where we'll be in the future, but there's so many resources in Africa, so many opportunities, so many talented people, and so many very young people that it's certainly something that we should all embrace and ensure. But thank you so much to everybody. I'm not sure if I've left anybody out. The audience, for listening, for being here, and for participating and asking very smart questions. Thank you so much. And I wish everybody, the very best for the rest of their day. Thank you.
Thank you very much, Mrs. Adiolu. I'm not sure there's any much for me to say other than to say thank you very much for being an amazing audience. Thank you very much to our speakers. We've had such a great time learning here today. And so we're just going to go to the last item on the agenda, which is pictures, but we are pretty much done here today. I wish you a very wonderful day ahead. Thank you.
A slight refreshment outside.
Yes, please.
And God bless Africa.